Good morning to the members of the Office of the Ombudsman, and welcome to the Office of Procurement Regulations Sensitization session. I am Tamara Roy, Head Corporate Communications, and we are extremely pleased that you're able to join us today. The team who will be presenting are Ms. Lindy-Ann Mitchell. She's our Head Legal, Melissa Ramkumarsingh, our Senior Capacity Development Specialist, Ms. Sanchel Ferreira, Complaints Officer, Melissa Mano, our Legal Officer, Ms. Nathifa Lowman, Senior Legal Officer, and Ms. Shireen Senanan, who is our Legal and Policy Research Officer. Before we begin the formal aspects of today's proceedings, please allow me to go through some helpful tips for a successful session. Do note that your mics will be muted during the presentation, but we will unmute when we reach the Q&A part of the session. Your questions during the session can be sent via the chat option on the Teams platform. These questions will be collated by our team and addressed in the Q&A segment at the end of the session. Please note that this session is being recorded and we will share it with you via email, and it will also be uploaded to our website. I would like to also express apologies on behalf of Mr. Bola, our Deputy Chair, who could not make the session today. So without further delay, we welcome our first presenter, Ms. Melissa Ramkumarsingh, who will take us through an overview of the Act and amendments. Melissa?
Thank you, Tamara. Good morning, everyone. The agenda this morning includes an overview of the Public Procurement and Disposal of Public Property Act 2015 and the 2016, 2017, and 2020 amendments to the Act. Following this, I'll hand you over to my colleagues who would provide some more in-depth information on complaints, challenge proceedings, and ineligibility proceedings. So before we look at some key provisions of the Public Procurement and Disposal of Public Property Act, let us first understand why this act is important. The World Trade Organization estimates that public procurement accounts for an average of 10% to 15% of a country's GDP. Because public procurement consumes such a significant portion of GDP, well-managed public procurement systems have the potential to lead to significant savings in public expenditure, increase investment, and improve the well-being of citizens. It is against this backdrop and some of the challenges presented by the existing procurement regime that the Public Procurement and Disposal of Public Property Act 2015 was introduced as a new framework for public procurement in Trinidad and Tobago. So let's take a closer look at the Act. The Public Procurement and Disposal of Public Property Act 2015 was partially proclaimed in July of 2015. This Act aims to provide for public procurement and for the retention and disposal of public property in accordance with the principles of good governance, namely accountability, transparency, integrity, and value for money. It is important to note that the Act not only incorporates procurement and the disposal of public property, but also brings the retention process into focus. In addition, it provides for the repeal of the Central Tenders Board Act, which makes up part of the current legislative framework. The Act also established the Office of Procurement Regulation, or the OPR, as a regulatory body governed by an independent board appointed by the President of Trinidad and Tobago after consultation with the Prime Minister and the Leader of the Opposition. The board of the OPR was appointed on January 12, 2018, and currently comprises 9 members in accordance with Section 10 of the Act. The OPR's independence is made clear in Section 13(2)(b) of the Act, which states that the OPR shall not be subject to the direction or control of any other person or authority in the performance of its functions, but shall be accountable to the Parliament. Now let's take a look at what the Act defines as a public body. According to Section 4 of the Act, a public body means the office of the President, the Parliament, the judiciary, a ministry or a department or division of a ministry, the Tobago House of Assembly or a division of the Tobago House of Assembly, a municipal corporation established under the Municipal Corporations Act, a regional health authority established under the Regional Health Authorities Act, a statutory body responsibility for which is assigned to a minister of government, a state-controlled enterprise, a service commission established under the Constitution or other written law, a body corporate or unincorporated entity using public money. With this broad definition of a public body, the Act brings all entities spending public money under a single regulatory framework. In the next slide, we will look at the definition of public money. Section 4 of the Act defines public money as money that is received or receivable by a public body, raised by an instrument from which it can be reasonably inferred that the state accepts ultimate liability in the case of default, spent or committed for future expenditure by a public body, distributed by a public body to a person, raised in accordance with a written law for a public purpose, or appropriated by Parliament. The Act requires that public bodies, including the Office of the Ombudsman, execute their procurement and disposal activities in a manner that is consistent with 11 objects which are explicitly outlined in Section 5. These objects are accountability. Accountability allows interested parties to establish whether objectives are being achieved. Accountability ensures that procurement professionals and public officers are held responsible for procurement decisions. Integrity. Integrity in procurement refers to the concept that procurement should be executed in a manner that ensures corruption and conflicts of interest are avoided. Transparency. Transparency requires that the appropriate information on the public procurement process is placed in the public domain, thus making it more difficult for corruption to go undetected. Value for money. Section 4 of the Act defines value for money as including the value derived from the optimal balance of outcome and input costs on the basis of the total cost of supply, maintenance, and sustainable use. In other words, value for money aims to maximize efficiency in procurement spending, considering not only the cost of acquisition, but also the cost of operation, maintenance, and the cost to the environment. Efficiency. Efficiency in public procurement means achieving procurement objectives within reasonable time and cost. For instance, by reducing administrative costs, resources, and time in the execution of the procurement function. Fairness. Fairness deals with ensuring a level playing field where all suppliers or contractors are treated equally. Equity. Equity means all suppliers or contractors have a fair chance of winning the contract. Public confidence. This deals with building trust and confidence in the integrity of the procurement process. Local industry development promotes the development of national suppliers or contractors, for example, through increased participation of nationals or through the transfer of knowledge. According to Section 4 of the Act, local industry development includes those activities that serve to enhance local capacity and competitiveness by involvement and participation of local persons, firms, capital markets, and knowledge transfer during the conduct of the program of goods, works, or services that are being procured. Sustainable procurement is defined by the Act as a process whereby public bodies meet their needs for goods, works, or services in a way that achieves value for money on a long-term basis, benefiting not only the public body, but also to the economy and the wider society whilst minimizing damage to the environment. And finally, sustainable development means meeting the needs of the present without compromising the ability of future generations to meet their own needs. So what are the functions of the OPR? According to Section 13 of the Act, the functions of the office are to establish a comprehensive database of information on public procurement, including information on tenders received, the award and value of contracts, and such other information of public interest as the office thinks fit. The information outlined here must be submitted by public bodies to the OPR within 3 weeks of the end of each quarter via the OPR's procurement depository. And you would hear more about the procurement depository later on in the presentation. The information submitted would form part of the OPR's database and would be included in the OPR's report to Parliament. To set training standards, competence levels, and certification requirements to promote best practices in procurement. Training standards, competence levels, and certification requirements have been developed for procurement, retention, and the disposal of public property. These standards are expected to aid in the development of public procurement capacity by identifying the knowledge, skills, and competencies that public procurement practitioners operating at the basic, intermediate, or advanced levels in procurement, retention, and the disposal of public property should possess. The standards developed by the OPR have been adopted. You can go on our website and access them. And we have also rolled it out to the named procurement officers, accounting officers, and human resource professionals in public bodies, as well as to educational institutions. To issue and review guidelines in relation to public procurement and the retention and disposal of public property. The OPR has issued approximately 28 general guidelines in relation to public procurement, retention, and the disposal of public property, which are available on the Resources tab of our website. To prepare, update, and issue model handbooks incorporating standardized bidding documents, procedural forms, and relevant documents for use in public procurement and the retention and disposal of public property. The OPR has issued 3 handbooks and 12 procedural templates, which are also available on our website. To approve in respect of each procuring entity, special guidelines and handbooks in relation to public procurement and the retention and disposal of public property. In instances where a public body determines that based on its unique circumstances, the general guidelines developed by the OPR, if adopted or amended, will not meet their needs, the public body would need to develop its own special handbooks and guidelines. Once developed, public bodies must submit the special guidelines to the OPR for approval. So as a public body, therefore, the Office of the Ombudsman would be required to review the model guidelines and handbooks developed by the OPR and determine which of the following 3 approaches best meets your needs. You can choose to adopt the handbooks and general guidelines issued by the OPR and inform us. You can amend the handbooks and guidelines, tracking the changes that were made and submit to us for approval, or you can develop your own special handbooks or guidelines and submit to the OPR for approval. The OPR is also required to promote the use of technology in public procurement and the retention and disposal of public property. This function includes the promotion of electronic approaches to public procurement, such as the introduction of an electronic procurement platform and electronic reverse auctions. The OPR would be encouraging the use of these at a later stage. To provide best practice advice in the conduct of procurement activities, including the promotion of electronic transactions. The OPR provides best practice advice in all areas, including the promotion of electronic transactions to our stakeholders via our sensitization sessions, as well as through our responses to stakeholder queries. To harmonize policies, systems, and practices in relation to public procurement activities and the disposal of public property. This deals with standardizing public procurement and disposal practices to benefit from synergies. To review procurement practices and delivery systems on an annual basis to identify best practices. This function speaks to continuous improvement of our procurement practices by having an ongoing process of review and identification of best practices, and this would be implemented following full proclamation. To determine, develop, introduce, maintain, and update related system-wide databases and technology. The OPR has already developed a procurement depository, and you'll hear more about this later on in the presentation. To promote the awareness of public bodies and the public to issues relating to public procurement and the disposal of public property. The OPR builds awareness via our sensitization sessions and our public advisories. Other functions of the OPR are to undertake research and surveys with respect to public procurement and disposal of public property. The OPR continues to undertake research to build capacity, liaising with relevant international institutions where required. We have also issued surveys to identify capacity gaps and to identify to assess the readiness of public bodies for implementation of the Act. For example, the Readiness Assessment Checklist. To act for, in the name and on behalf of the state, to dispose of real property owned by the government in such manner as the government may consider appropriate and desirable. This function was removed from the OPR's purview, and more details would be provided during our review of the amendments to the Act. To create and publish standard form contracts for public procurement and disposal of public property. The OPR would be developing standard form contracts that can be used across all public bodies, and this would save on legal costs as well as time. To prepare and maintain a database of pre-qualified contractors and suppliers. Once the Act is fully proclaimed, suppliers or contractors will need to be pre-qualified to participate in public procurement proceedings. To facilitate this, the OPR has established the Procurement Depository, which can be accessed on the OPR's website. Using the depository, suppliers or contractors can register to provide goods or services to public bodies, and public bodies can review the submissions and pre-qualify the suppliers or contractors for the required goods and or services. And more information would be provided later on in the presentation. To prepare and maintain a list of pre-qualified mediators, arbitrators, and experts for the purposes of alternative dispute resolution. This would be facilitated via the Procurement Depository. To provide advice on best practice on the aggregation of procurement or disposal of goods for the purpose of obtaining value for money. Section 27(1) of the Act, which will be detailed later on, requires public bodies to publish information on their forthcoming procurement annually. Using this information, public bodies can identify the goods and services that other public bodies will also be procuring in the forthcoming year, thus allowing the opportunity for aggregation and obtaining value for money. The OPR is also required to audit and review the system of procurement and disposal of public property to ensure compliance with the objectives of the Act, and to investigate on its own initiative or upon complaint from any party involved in public procurement or disposal of public property, or any member of the public, any alleged or suspected breach of this Act. The OPR has recruited staff with the required training and experience to execute these responsibilities once the Act is fully proclaimed. Let's now look at the roles and responsibilities of the accounting officer. The Financial Regulations of the Exchequer and Audit Act sets out the accountabilities of accounting officers as follows. Section 4 states that an accounting officer shall be responsible for ensuring that the financial business of the state for which he is responsible is properly conducted, and that the public funds entrusted to his care are properly safeguarded and are applied only to the purposes intended by Parliament. Additionally, Section 5 states that all accounting officers are personally and pecuniarily responsible for the due performance of the financial duties of their department, the proper collection and custody of all public monies receivable by them, and for any accounts rendered by them or under their authority. Some additional details on the responsibility of the accounting officer are outlined at sections 6, 7, and 11 of the Financial Regulations of the Exchequer and Audit Act. Based on these sections, it is clear that the accounting officer is ultimately responsible, even in circumstances where execution is delegated to a subordinate. So who is responsible for procurement? Section 61(2) of the Act states that for the purpose of this Act, a public body shall have a procurement officer who shall be responsible for public procurement and the disposal of public property for that body, and shall notify the office in writing of the name and designation of its procurement officer. And this is the person that the OPR identifies as the named procurement officer. Section 61(3) further states that a reference in this Act to the commission of an offence by a public body shall be construed as a reference to the commission of the offence by the procurement officer referred to in subsection 2, or an officer who purports to act in such capacity, if it is proved that the offence was committed with his direct consent or connivance, or he, with knowledge, did not exercise reasonable diligence to prevent the commission of the offence. Note that the procurement officer is therefore responsible and liable, but in instances where any other officer assumes this responsibility and acts in the capacity of the named procurement officer, then that officer would be culpable. Given the important role of the named procurement officer, it is important to ensure that this individual possesses the requisite skills and competence to manage the complexity of procurement being executed by your public body. Let us now discuss the Procurement and Disposal Advisory Committee. Part 9, Regulation 21, subsection 1 of the Public Procurement and Disposal of Public Property Procurement Methods and Procedures Regulations 2021 stipulates the requirement for the establishment of an advisory committee called the Procurement and Disposal Advisory Committee, or PDAC. Regulation 21, subsection 2 then provides the composition of PDAC, and this includes the corporate secretary or head of legal, head of finance, a subject matter expert, and such other members as may be necessary. Subsection 3 stipulates that a member of PDAC may be sourced from another public body, and this may be useful in circumstances where a public body does not have the required subject matter expertise. Regulation 21, subsection 4 goes on to state that a senior officer shall be appointed as the secretary to attend all meetings of the committee, but shall not be a member of the committee. And this secretary plays a key role in ensuring effective administration, record keeping, management, as well as governance within the committee. Regulation 21, subsection 5 outlines the role of PDAC, stating that the committee shall review reports, recommendations for contract award, and procurement proceedings and property disposal files to determine whether there was adherence to the Public Procurement and Disposal of Public Property Act and the regulations, adherence to the handbooks and guidelines, and these are the handbooks and guidelines that have been adopted, adapted, or developed and approved for use by the Office of the Ombudsman, adherence to the approved procurement or disposal strategy, and the procurement or disposal strategy would document the analysis undertaken for the specific good or service being procured or disposed of, and outline the most suitable procurement or disposal approach. So therefore, PDAC must ensure that the approved strategy was followed and any material adjustments to the strategy was documented. And finally, achievement of the objects of the Act. So in its role, PDAC provides an added level of assurance to the accounting officer. Regulation 21 subsection 6 states that if PDAC is of the opinion that any aspect of sub-regulation 5 has not been complied with or adhered to, PDAC shall recommend the appropriate action to the procurement officer in writing with an explanation of the reasons for its decision. According to Regulation 21 subsection 7, the written recommendation and explanation of PDAC must also be forwarded to the accounting officer for noting. On the other hand, Regulation 21 subsection 8 states that where there's an agreement, PDAC is required to provide the accounting officer with a written recommendation, which must be accompanied by the procurement proceedings file and property disposal file. Now, to ensure that there is integrity and objectivity in the execution of PDAC's role, and that the recommendations made are free from bias or perceived bias, Regulation 21 subsection 9 requires that a member of the committee shall disclose his interests and not take part in proceedings of the committee where he is a member, director, or shareholder of a company or other body corporate, is a proprietor or a partner in a firm or partnership, is employed by or is otherwise a party to a contract for services, has a financial interest in or relationship with someone, is a relative of an individual being reviewed by the committee. So in summary, this diagram illustrates the different levels of review and approval in the procurement and disposal process. At the first level, we have the disposal committee and the evaluation committee. With respect to disposal, Section 55 of the Act specifies the requirement for the establishment of a disposal committee comprising no less than 3 persons. The role of the disposal committee is to recommend the best method of disposing of unserviceable, obsolete, or surplus stores or equipment. This recommendation for disposal would be made by the disposal committee to the named procurement officer. On the other hand, we have the evaluation committee, which would evaluate submissions received in response to a solicitation and make a recommendation to the named procurement officer. The named procurement officer will review the recommendation of the disposal committee and or evaluation committee detailed in the procurement or disposal file, and once there is agreement, the respective file with all the relevant details would be submitted to PDAC for review. PDAC will then review the procurement and property disposal file in accordance with Regulation 21 subsection 5, which was outlined previously, and make a recommendation. In the case of non-compliance, PDAC will recommend the appropriate action to the named procurement officer in writing, providing the reasons for its decision. This explanation will also be sent to the accounting officer for noting. When the accounting officer receives the recommendation, he or she will review and accept or reject. In the case of a disposal action, the accounting officer must provide a written notice of his or her decision to accept or reject the decision of the disposal committee within 14 days of receipt. Where the recommendation with respect to a disposal is rejected, the reasons must be provided in writing, and the accounting officer must consult the line minister and determine how the item is to be disposed of. The OPR must be provided with a copy of the notice of rejection of the disposal decision and the reasons for this rejection. In the case of procurement, if the accounting officer rejects the recommendation of the evaluation committee and PDAC, the reasons must also be provided in writing to the NPO in the procurement proceedings file. Any supporting information as well as any request that is issued that an issue should be addressed by the evaluation committee should also be included in the file. On the other hand, if the accounting officer accepts the procurement or disposal decision, then the decision is executed. Note that in circumstances where a public body is governed by a board of directors, the accounting officer may submit the decision to the board for non-objection. In circumstances where the board objects, the reason must be provided in writing for consideration by the accounting officer. However, the final decisions rests with the accounting officer. In terms of the illegality of procurement or disposal, according to Section 6(1) of the Act, any procurement of goods, works, or services, or retention or disposal of public property that is not done in accordance with this Act, and any procurement contract or agreement that is not entered into in accordance with this Act shall be void and illegal. Additionally, Section 13(2)(a) of the Act states that in the exercise of its functions, the office shall act expeditiously and take such other steps as it thinks fit in order to minimize any negative economic impact arising out of the performance of its functions. Let us now look at some highlights from the Act. The Act in Section 27 introduces the requirement for procuring entities to publish information on forthcoming procurements. According to Section 27(1), a procuring entity shall, no later than 6 weeks after the approval of the national budget, publish on its website or in any other electronic format information regarding all planned procurement activities for the following 12 months. We refer to this as the annual schedule of planned procurement activities. Additionally, the procuring entity must update the information as necessary and provide a printed copy of this information upon request and payment of a prescribed fee. Section 27(2) goes on to state that where the information referred to in subsection 1 is unavailable or not forthcoming, a complaint may be made to the office, which shall conduct an investigation in accordance with Section 41, and if justified, grant an extension of time or issue such direction as it thinks fit. This publication of information on planned procurement activities for the upcoming 12 months encourages procuring entities to plan their procurement and reduce the incidence of ad hoc procurement. It can also benefit suppliers or contractors by allowing them to identify upcoming opportunities that they may wish to participate in. As mentioned previously, this can also provide procuring entities with the opportunity to benefit from savings by aggregating procurement for common items. Another highlight from the Act is the requirement for the establishment of the procurement depository. This was briefly mentioned earlier in the presentation, but this requirement is outlined in detail at Section 26 of the Act. Section 26(1) of the Act states that the office shall establish a database to be known as the Procurement Depository, to which suppliers or contractors can submit information with respect to, among other things, their qualifications and experience. So in keeping with this requirement, the OPR has established the Procurement Depository, and many suppliers or contractors have already uploaded information with respect to their qualifications and experience, legal capacity, and other information as required. Section 26(2) states that the procurement depository shall be accessible by the public for viewing. The procurement depository can be accessed on the OPR's website. Section 26(3) places the responsibility for ensuring the accuracy of the information submitted to the procurement depository on the supplier or contractor, while Section 26(4) allows the procuring entity the ability to request that a supplier or contractor who has submitted information to the procurement depository to confirm the accuracy of the information submitted when conducting its due diligence pursuant to Section 29(1)(e). And for context, Section 29(1)(e) deals specifically with ensuring that the supplier or contractor has the necessary professional and technical qualifications, competence, financial resources, equipment, and other physical facilities, managerial capability, reliability, experience, and personnel to perform the procurement contract. And we'll meet this requirement again when we go through the due diligence requirements of the Act. So as mentioned previously, one of the functions of the office is to prepare and maintain a database of pre-qualified suppliers or contractors. Outlined here are the definitions of pre-qualification and pre-selection as defined by the Act. Section 4 of the Act defines pre-qualification as a procedure to identify, prior to solicitation, suppliers or contractors who are qualified. Pre-qualification is a pass or fail procedure used to ensure that the suppliers or contractors that are being invited to submit an offer already meet certain pre-established minimum capability standards to supply particular goods, works, or services. Pre-selection, according to Section 4 of the Act, is the procedure to identify, prior to solicitation, a limited number of suppliers or contractors who best meet the qualification criteria for the procurement concerned. So unlike the pre-qualification process, pre-selection identifies the most eligible applicants to deliver on a specific procurement contract. This is done by assessing and ranking the suppliers or contractors against specific qualification requirements. You can obtain some more information on these processes in the general guidelines on pre-qualification and pre-selection published on the OPR's website. So in order to determine whether a supplier or contractor is qualified to be included in the database of pre-qualified suppliers or contractors, public bodies must ensure that the suppliers or contractors meet the due diligence requirements outlined in Section 29(1) of the Act. Section 29(1) states that a public body engaged in procurement proceedings must ensure that suppliers or contractors A. have the legal capacity to enter into the procurement contract, B. are not insolvent, in receivership, bankrupt, or being wound up, their affairs are not being administered by a court or a judicial officer, their business activities have not been suspended, and they are not the subject of legal proceedings for any of the foregoing. C. have not, and their directors or officers have not been convicted of any criminal offense. Section 29(1)(c) is highlighted in red since this was amended in the 2020 amendments, and we will address this later in the presentation. Continuing with Section 29(1), a procuring entity shall ensure that suppliers or contractors D. have fulfilled their obligations to pay all required taxes and contributions in Trinidad and Tobago, E. have the necessary professional and technical qualifications and competence, financial resources, equipment, and other physical facilities, managerial capability, reliability, experience, and personnel to perform the procurement contract, and F. meet the relevant industry standards. So these are the requirements that suppliers or contractors must meet to be added to the database of pre-qualified suppliers or contractors maintained by the OPR. Section 29(3) states that any requirement established pursuant to this section shall be set out in the pre-qualification or pre-selection documents, if any, and the solicitation documents shall apply equally to all suppliers or contractors. This ensures that there is transparency and fairness in the process. A key point to note with respect to pre-qualification is that once the Act is fully proclaimed, all suppliers or contractors interested in supplying goods, works, or services to public bodies in Trinidad and Tobago must be pre-qualified. Another important feature of the Act is the introduction of a standstill period. In simple terms, the standstill period is a short pause between the identification of the successful submission and the award of the procurement contract or framework agreement to allow for any challenges to the proposed award to be raised and dealt with. The standstill period should be no fewer than 10 working days and no more than 15 working days as specified in the solicitation document. The introduction of the standstill period mitigates the risk that a project may be halted or suffer a long delay due to bid-related complaints after the contract has been awarded. In terms of applicability, Section 35(4) states that the standstill period shall not apply to the award of procurement contracts where procuring entity determines that urgent public interest considerations require the procurement to proceed without a standstill period. And urgent public interest considerations refer to issues that can negatively affect the rights of citizens of Trinidad and Tobago. For instance, the collapse of a bridge which hinders the free movement of persons to and from their homes. Further information on the standstill period would be provided by my colleagues later on in the session. As mentioned earlier, the Act not only applies to the acquisition of goods, works, or services, it also applies to retention and disposal of public property. Section 4 of the Act defines public property as real or personal property owned by a public body. In the case of retention and disposal, a public body shall comply with such general guidelines in relation to the retention and disposal of stores and equipment of a public body as the office may issue, and such special guidelines in relation to the retention and disposal of stores and equipment of a public body as the office may approve for that public body. Another aspect of the Act highlighted here is the opportunity for suppliers or contractors to challenge procurement decisions made by procuring entities. Section 49(1) states that a supplier or contractor may bring challenge proceedings where it is alleged that a procuring entity made a decision or took action that is not in compliance with this Act, and the supplier or contractor has suffered or is likely to suffer loss or injury because of the decision or action of the procuring entity. In addition, Section 51 of the Act states that a supplier or contractor may apply to the office for review of a decision or an action taken by a procuring entity in procurement proceedings. And more information would also be provided on challenge proceedings by my colleagues later on in the session. The Act also introduces an ineligibility list, which is defined as a list of suppliers or contractors who shall not participate in procurement proceedings. Section 58(3) outlines the circumstances under which the office may add a supplier or contractor to the ineligibility list, specifically stating where the supplier or contractor consistently fails to provide satisfactory performance, is found to be indulging in corrupt or fraudulent practices, or is convicted of an offense under this Act. It is important to note that in accordance with Section 58(5), a supplier or contractor shall be accorded an adequate opportunity to be heard and to make representation before he is added to the ineligibility list pursuant to this section. Again, more information would be provided on ineligibility proceedings by my colleagues later on in the session. So now let us look at some specific impacts of the Act, most of which we would have gone through already. First, we have the repeal of the Central Tenders Board Act and the removal of the Central Tenders Board. With this, public bodies now have to carry out all their procurement and disposal activities. The requirement to appoint a named procurement officer as specified in Section 61(2) of the Act, the need for the establishment of a disposal committee, the establishment of the Procurement and Disposal Advisory Committee as required by Part 9 of the Procurement Methods and Procedures Regulations 2021, the requirement to publish information on forthcoming procurement and the development of the annual procurement plan, the requirement for public bodies to have approved procurement handbooks and special guidelines, the requirement for implementation of the internal control framework for public procurement, and we wouldn't have gone through this one, but more information on this can be obtained in the general guidelines framework for internal control for procurement, which is available on the OPR's website. The Act also introduces several offenses and penalties that would apply when breaches occur, and these include the following. The first offense specified under Section 14(2) of the Act is the failure by a person or public body to comply with a direction issued under the Act. The specified penalty is a fine of $100,000. Section 17(2) identifies the failure of a member of the board of the OPR or a committee constituted by the board to disclose an interest knowingly or willfully as an offense. The penalty associated with this offense is $500,000 and 1 year imprisonment. The next offense relates to Section 31 of the Act, which addresses the splitting of procurement. Section 31 states that a procuring entity shall not split procurement requirements for a given quantity of goods, works, or services to avoid obligations under the Act. The penalty for splitting is $500,000 and 1 year imprisonment. Section 39 of the Act addresses confidentiality. The offense under this section is the failure of a procuring entity to comply with requirements with respect to confidentiality of information. The penalty for breach of confidentiality is $500,000 and 1 year imprisonment. Section 40 of the Act speaks to the prohibition of victimization. The penalty attached to victimization is $500,000 and 1 year imprisonment. The offense specified in relation to Section 41 of the Act is the failure of a person to report instances of collusion. The associated penalty is $500,000 and 1 year imprisonment. Section 41(4) of the Act identifies the submission of a false report to the office as an offense. The associated penalty is $500,000 and 1 year imprisonment. The offense in relation to Section 46 of the Act is concealing or destroying information required for an investigation. The applicable penalty is $5 million and 10 years imprisonment. Section 52 of the Act addresses failure to comply with requirements with respect to confidentiality in challenge proceedings. The applicable penalty is $500,000 and 1 year imprisonment. Section 59 of the Act identifies conduct influencing a public officer as an offense. It addresses bribery, conflicts of interest, corruption, fraudulent, collusive, coercive, or obstructive practices. The specified penalty is $1 million and 5 years imprisonment. Section 61 of the Act addresses offenses that relate to persons who are involved in or participate in bid rigging and persons who directly or indirectly influence or attempt to influence procurement proceedings. The specified penalty for this offense is $5 million and 10 years imprisonment. Section 62 of the Act deals with altering a procurement document to influence the outcome of procurement proceedings. The associated penalty is $2 million and 7 years imprisonment. And finally, in accordance with Section 63(1) of the Act, the Minister, on the recommendation of the office, may make regulations to give effect to the provisions of the Act, including regulations with respect to challenge proceedings and the addition to or removal from an ineligibility list. In this regard, Section 63(2) of the Act identifies the contravention of a regulation made by the Minister as an offense. The specified penalty for this offense is up to $1 million and 5 years imprisonment. These offenses and penalties highlight the importance of ensuring that your procurement, retention, and disposal actions are in alignment with the Act, regulations, and approved handbooks and guidelines. So let's now go through the amendments to the Act. The Public Procurement and Disposal of Public Property Act 2015 was amended in 2016, 2017, and 2020 as follows. The Public Procurement and Disposal of Public Property Amendment Act 2016 provides for the establishment of the Public Procurement Review Board. This board provides the opportunity for those affected by decisions of the Office of Procurement Regulation to have those decisions reviewed. The Public Procurement and Disposal of Public Property Amendment Act 2017 provides for a reduction in the term of office of the regulator from 7 years to 5 years, and the terms of the other members have also been reduced. Members who would have had a 6-year term will now serve for 4 years, and members with 5- and 4-year terms will now have 3-year terms. The Public Procurement and Disposal of Public Property Amendment Act 2020 provides for 7 amendments, and I will review these in the next few slides. So this slide summarizes the 7 features of the Public Procurement and Disposal of Public Property Amendment Act 2020. So let's take a look at each of these amendments in greater detail. Firstly, the definition of bid rigging was changed. Based on legal advice obtained by the OPR, the previous definition of bid rigging, which is highlighted in black, did not constitute an offense. So the definition was changed. Bid rigging is now defined as collusive price fixing and anti-competitive behavior, which is designed to unfairly influence the outcome of a competitive tender process in favor of one or more bidders. Section 7 of the Act, which deals with the application of the Act, was also amended. The part highlighted in red represents what was removed. So previously, where the Act conflicted with an obligation of the state under or arising out of treaties or agreements specified at Section 7, subsection 2A, B, and C, the requirements of the treaty or agreement would have prevailed, but the procurement of goods, works, or services would be governed by the Act, promote the socio-economic policies of Trinidad and Tobago, and adhere to the objects of the Act. But based on the amendment, now where this Act conflicts with an obligation of the state arising out of the treaties or agreements specified again at Section 7, subsection 2A to C, the requirements of the treaty or agreement will now prevail. And the agreements or treaties that are specified at Section 7, subsection 2 are A, a treaty or other form of agreement to which Trinidad and Tobago is a party with one or more states or entity within a state, an agreement entered into by the government of Trinidad and Tobago with an international financing institution such as the Inter-American Development Bank, an agreement for technical or other cooperation between the government of Trinidad and Tobago and the government of a foreign state. In addition, it should be noted that a procuring entity engaged in procurement proceedings relating to a treaty or agreement referred to in subsection 2A shall comply with section 29 and submit a report on such compliance to the office. And you may recall that section 29 speaks to the due diligence requirements of the Act. Additionally, based on the Public Procurement and Disposal of Public Property Amendment Act 2020, the report required under Section 7(3) of the Act no longer applies to reports regarding matters of national security. Another amendment was made to Section 7 via the 2020 Amendment Act, and based on this amendment, the Act shall no longer apply to legal services, debt financing services for the national budget, accounting and auditing services, medical emergency or other scheduled medical services, and note here that the Act still applies to the procurement of medical goods, so the exemption is only for medical emergency and other scheduled medical services, or such other services as the minister may by order determine. So in addition, the minister shall submit to the office annual guidelines which outline the circumstances under which the exempted services may be procured. So it's exempt from the Act, but they still must comply with the guidelines defined by the minister. In the 2020 Amendment Act, Section 13(1) of the Act is amended by deleting paragraph O, which relates to the functions of the office with respect to the disposal of real property. This came as a result of a recommendation made by the OPR, which sought to preserve the independence of the office with respect to the audit and investigation of real property disposal. Based on this amendment, the OPR would no longer be responsible for executing real property disposal, but the responsibility for audit and oversight of real property disposal will be retained. Section 29(1)(c), which related to the due diligence requirements, has also been amended. Previously, a procuring entity would have had to ensure that suppliers or contractors have not, and their directors or officers have not been convicted of any criminal offense, and this is highlighted in red, regardless of the nature or time frame for the offense. Recognizing the limited nature of this clause to persons with minor convictions, the OPR recommended that Section 29(1)(c) of the Act be amended. And based on the 2020 Amendment Act, this due diligence requirement will now only apply to convictions within the past 10 years of corruption or fraud-related offenses locally or internationally as individuals or as directors or officers of a company. Section 50, subsection 12 of the Act was amended to allow the office 30 days instead of 20 days to give its decision in writing after the review of a decision or an action taken by a procuring entity in respect of procurement proceedings. And finally, Section 59, which deals with the conduct influencing a public officer, was amended. Under Section 59(1), the definition of the term relative was amended to include a common law relationship. Section 59(1)(a) now reads, for the purpose of subsection 1, relative means a spouse, cohabitant within the meaning of the Cohabitational Relationships Act, father, mother, brother, sister, son, or daughter. This now brings me to the end of my portion of the presentation, and thank you very much for your attention.
Hey everyone. Now we are going to take you through the process of submitting a complaint to the OPR. The following topics will be addressed. What is a complaint under Part 4 of the Act? Who can make a complaint? What can I complain about? Who can I complain about? How to file a complaint, how complaints are handled, the possible outcomes if an investigation occurs, distinguishing between whistleblowing reports from complaints under Part 4 of the Act, and finally, we will address frequently asked questions, followed by a short quiz. Outlined in Section 13 and 14 of the Act, the OPR has numerous functions and powers. We are now going to look at those powers and functions that are directly relevant to the complaints process. The OPR's functions are to audit and review the procurement systems and disposal and retention of public property in public bodies, to review procurement practices and delivery systems on an annual basis, to identify best practices, and to investigate any alleged or suspected breach of the Act. The investigations can be prompted in two main ways. Firstly, by the OPR's own initiative. This may be a matter that comes to the attention of the OPR, perhaps from a newspaper article or online story of great public interest involving public procurement or disposal of public property. And secondly, upon receipt of a complaint. OPR's powers include the power to monitor procurement activities and disposal and retention of public property within public bodies, to conduct audit and periodic inspection of public bodies to ensure compliance with the Act, and to direct public bodies to ensure compliance with the Act. So now let's get into what exactly is considered a complaint under Part 4 of the Act. A complaint is a formal written statement of an allegation that bid rigging or any other form of collusion, an irregularity in an irregularity in procurement proceedings or a breach of the Act has occurred. Next, we get into who can make a complaint. In accordance with Section 41 of the Act, any member of the public may make a complaint regarding breaches of the Act. The OPR may also consider, inquire into, or investigate any alleged breaches of the Act where a complaint has not been made by a member of the public. Let's get into what can be complained about. It is important to note that the OPR will only investigate complaints that are relevant to its mandate. Under Section 41(2) of the Act, there are three categories of complaints that can be brought to the attention of the OPR. These are bid rigging or other forms of collusion between all or any parties to procurement proceedings, an irregularity in procurement proceedings, or a breach of the Act. It is important to note that a breach of the Act also covers a breach of the provisions concerning retention and disposal of stores and equipment of a public body. In the following slides, we'll take a closer look at these areas. The first area is bid rigging. Bid rigging is defined as collusive, price fixing, and anti-competitive behavior, which is designed to unfairly influence the outcome of a competitive tender process. If we look closely at the photo in this slide, we can get a feel for how bid rigging can occur. A, B, and C are bidders from separate entities who are all participating in this tender process. They have all prepared individual proposals, but it appears that they all have a silent agreement on understanding that B would be the winning proposal. In essence, they have agreed amongst themselves or colluded to directly or indirectly influence the outcome of the tender process in favor of B. In another tendering process, this same collusion may take place in favor of possibly A or C. This type of behavior is an offense pursuant to Section 61 of the Act. As mentioned earlier in this session, the definition of bid rigging was amended by Act number 27 of 2020. Next, we go on to an irregularity in procurement proceedings. This may refer to a deviation from or non-compliance with the requirements outlined in the Act, the regulations, or the handbooks and guidelines issued by the OPR in accordance with the Act. These irregularities may also refer to loopholes that create favorable conditions for corruption within the procurement process. This includes the process of procurement from the planning stage, from soliciting of tenders, awarding of contracts, and contract management. For example, Section 29(1)(e) of the Act requires that the procuring entities ensure that suppliers and contractors have the necessary professional and technical qualifications, competence, and financial resources to perform the procurement contract. Where procuring entities fail to do this, it may constitute an irregularity in procurement proceedings. Other examples include deviation from terms of request for proposals, failure to publish annual procurement plans, and failure to conform to the pre-qualification regulations for procurement. Breaches of the Act. Now we look at a breach of the Act refers to the commission of an offense under the Act or failure to adhere to any of the obligations outlined in the Act. Examples of which are splitting of procurement, which is where the quantity of goods, works, or services are split into lots to avoid obligations under the Act. Breach of confidentiality. The procuring entity shall not disclose any discussions, negotiations that would prejudice the commercial interests of suppliers or contractors. Failure of a public body to refer all matters relating to the disposal of unserviceable, obsolete, or surplus stores or equipment to disposal committee. It is important to note that a single complaint may have an overlap of categories depending on the facts outlined in the complaint. It is possible that one complaint can speak to all three of the elements that can prompt an investigation. You may be interested to know who a complaint can be made about. A complaint can be made about all public bodies and all or any interested parties to procurement proceedings. This includes the Office of the President, the Parliament, the Judiciary, a regional health authority, a municipal corporation, the Tobago House of Assembly, a ministry department, or division of a ministry. Also, complaints can be made against a statutory body, a state-controlled enterprise, any body or body corporate that uses public money, or in relation to any function that is exercised on behalf of the state, an accounting officer, parties to the public-private partnerships, any interested party to procurement proceedings, a service commission, as well as a named procurement officer. It is important to remember that complaints against these persons and public bodies can only be made in relation to public procurement and disposal of public property. You may be wondering, how is this OPR's Part 4 complaints mechanism important to the Office of the Ombudsman? Firstly, in consideration of the functions of the Ombudsman outlined in Section 93 of the Constitution, the Office of the Ombudsman is considered a public body under the PPDPP Act. Therefore, any procurement or disposal and retention activities performed by the Office of the Ombudsman must be performed in accordance with the requirements of the Act. In performing its procurement function, employees of your office may have reason to submit a complaint to the OPR in appropriate cases. This may be the case where the Office of the Ombudsman has evidence that a supplier or contractor has engaged in bid rigging or some other form of collusion. On the other hand, a member of the public, such as a supplier or a contractor, may submit a complaint to the OPR alleging that the Ombudsman Office has breached a provision of the Act. Now I will hand you over to Ms. Mano, who will take you through the next step of this session.
Thank you, Sanchel. Good morning to all members of the Office of the Ombudsman. Now, I will be discussing with you how complaints are filed with the OPR. A complaint is filed with the OPR by submitting a complaint form. This can be done online, via mailing, or walk-in submission to the OPR at Level 19, Tower D, International Waterfront Center, 1A Rising Road, Port of Spain. It is important to note when submitting a complaint that you include your name, mailing address, telephone contact details, email address, information about the subject of the complaint, particulars of the complaint, and supporting documents. A few important tips to note for persons wishing to submit a complaint to the OPR. Please consult the guidance notes before completing the form. These notes can be found on the OPR's website. Provide adequate supporting documents where possible. Use clear and concise language. Be specific. Use dates, times, locations, and names as far as possible. Provide the names of persons or witnesses who can provide evidence of the allegations made. Ensure that you provide up-to-date contact information so that you can be contacted by the OPR if necessary. Cooperate with authorized officers of the OPR when called upon. How will the complaints be handled by the OPR? The complaint process involves several stages, which includes an intake of your complaint, an acknowledgement of your complaint, an initial assessment by the legal department, an investigation, and if necessary, further assessment and a final outcome. When you submit a complaint to the OPR, it is important that you submit a complete complaint form. The complaints officer will be there to assist you. He or she is your first point of contact and will provide any assistance you may need in lodging your complaint. They will ensure all formalities are met, but will not influence the substance of any information you may provide to the office. Once the OPR receives your complaint will be assigned a complaint number, and you will be issued an acknowledgement of receipt of your complaint, which will include your complaint number and the next steps. This acknowledgement will be communicated to you either at your email address, mailing address, or mode of service you provided to us. Your complaint is then sent to the legal department of the OPR. The legal department conducts an initial assessment of all complaints to determine whether there are sufficient grounds to warrant an investigation and whether your complaint falls within Section 41 of the Public Procurement and Disposal of Public Property Act. It is important to note that a complaint can be made in relation to bid rigging or any forms of collusions between all or any of the interested parties to procurement proceedings, an irregularity in procurement proceedings, or any breaches of the Act. The OPR can also investigate these matters on its own initiative. Where there are insufficient grounds to warrant an investigation, reasons will be provided to you. Where the legal department determines that the matter do fall within the remit of the OPR and there exist sufficient grounds to warrant an investigation, the matter will be sent to the Audit and Investigations Department for an investigation to be conducted. The Audit and Investigations Department will devise an investigation plan, gather all necessary evidence, conduct interviews, perform site visits, and enter and seize any vital information, documents, or materials, and on conclusion of an investigation, will prepare an investigation report. It is important to note that the OPR can, for the purpose of conducting an investigation, require any person to supply or produce to the office or to a person specified any book, record, document, or information needed for an investigation. This is alike the power granted to the Office of the Ombudsman under Section 4.1 of the Ombudsman Act to summon witnesses and to compel them to give evidence on oath and to produce documents. The OPR can also require a person to attend the office or any other place to give orally or in writing information on oath or affirmation. This is in accordance with Section 42, subsection 1 and subsection 42. This is in accordance with Section 42, subsection 1D and Section 42, subsection 4. Again, this is similar to Section 4, subsection 2 of the Ombudsman Act, which allows the Ombudsman to summon before him and to examine on oath any person who is an officer or employee or member of any department or authority towards Section 93 of the Constitution of Trinidad and Tobago applies, as well as any complainants or any other person who, in the Ombudsman's opinion, is able to give any relevant information, and for that purpose may administer an oath. A person who is required to provide information to the OPR may be represented by counsel and may claim any privilege to which that person is entitled. Again, this is similar to Section 92, subsection 1 of the Constitution of Trinidad and Tobago, where all persons giving evidence to the office of the Ombudsman shall have the same duties and liabilities and shall enjoy the same privileges as in the High Court. Where a person who is required to appear before the office or give information fails or refuses to appear or provide information without lawful justification, the office may make an application to the High Court to compel the person to do so. This is in accordance with Section 42, subsection 6 of the Public Procurement and Disposal of Public Property Act. An authorized officer of the OPR can also examine and inquire into the affairs of a public body or person in respect of whom an investigation is being conducted, can examine and make copies of or remove from the premises of a public body or person all such books, records, and documents or other things relating to the subject of an investigation, and can also enter the premises of a public body or public person during reasonable hours for the purpose of conducting an investigation. This is similar to the powers granted to the Office of the Ombudsman under Section 92, subsection 2 of the Constitution of Trinidad and Tobago. It's important to note that an authorized officer of the OPR will not enter the premises of a public body or person unless the office first obtains on an ex parte application to a judge of the High Court an order authorizing him to enter the premises to conduct an investigation. The office will ensure the due process is adhered to. This section can be contrasted with Section 7 of the Ombudsman Act, which states before entering upon any premises pursuant to Section 97, subsection 2 of the Constitution of Trinidad and Tobago, the Ombudsman shall notify the principal officer of the department or the authority by which the premises are occupied. The difference between these two sections is that the Office of the Procurement the OPR must, prior to entering the premises of a public body or public person, must first obtain on an ex parte application order from the High Court. It is important to note that OPR does not have an unfettered power to enter the premises of a public body or person for the purpose of conducting an investigation. The legal department must first file an application to a judge of the High Court stating sound and justifiable reasons, supported by affidavit evidence. Why such an order is required, it is only when the office is in receipt of a court order authorizing entry into the premises of a public body or public person for the purpose of conducting an investigation will an authorized officer of the OPR enter the premises of a public body or public person to conduct an investigation. Just 1 minute. We're just trying to change the slides, okay, so that you can follow. Okay. So on the conclusion of an investigation, the Audit and Investigation Department prepares an investigation report and submits that report and an investigation file to the Legal Department for further assessment. The Legal Department reviews and determines whether the allegations made in the complaint are substantiated and prepares a report and recommendation for the Investigative Oversight Committee. The IOC is a committee that has been established by the board pursuant to Section 16 of the PPD-PPA. The IOC reviews the report and recommendation of the Legal Department and makes a final decision on whether a matter should be referred to the Director of Public Prosecutions, together with any other recommendations. I'll now discuss with you protection of complainants. Filing a complaint with the OPR in relation to breaches of the Act can be intimidating, so we thought it important to highlight the ways in which the Act offers some protection for complainants. In your place of employment, you may obtain some information about breaches of the Act and may wish to file a complaint. However, based on the nature of the terms of your employment, you may be bound by duty of confidentiality to your employer and may be worried that you would be in breach of that duty if you file a complaint. However, Section 47 of the Public Procurement and Disposal of Public Property Act states, notwithstanding any other written law, no person shall be regarded as having breached any duty to which he may be subject by reason of his communication in good faith to the office of any information or opinion on a matter which is relevant to any function of the office under this Act, whether or not in response to requests made by the office. The effect of Section 47 is that you will not be deemed to be in breach of such a duty in providing information to the office once you act in good faith. This applies whether the OPR requests this information from you or whether you volunteer to give this information. Another main reason why employees may be afraid to file a complaint is because they are afraid of being victimized. In the context of the workplace, victimization can take the form of a dismissal, suspension, demotion, harassment, discipline, denial of a benefit, or otherwise negatively affecting a person. The Act prohibits this kind of retaliation against any person who, acting in good faith and on the basis of a reasonable belief, has notified the OPR, the Director of Public Prosecutions, the Integrity Commission, the Trinidad and Tobago Police Service, that his employer or any other person has breached or is about to breach the Act. If you feel that you are being victimized, it's important to note that you can make a report to the OPR, which will be investigated. Any person found guilty of victimization is liable on conviction to a fine of $500,000 and imprisonment for 1 year. I'll now hand you over to Ms. Lowman, who will take you through the other aspects of the presentation.
Thank you, Melissa, and good morning, everyone. So now that we've examined the complaints handling process, I'm going to take you through the possible outcomes after an investigation. These outcomes may vary on a case-by-case basis. However, in general, the four main outcomes are, firstly, that there be no further action, that there be correspondence issued to the parties, a notice of adverse report and an opportunity to be heard, or a report can be made to the Director of Public Prosecutions. A determination on the outcome would be made after the Audit and Investigations Department has completed its investigation report. Thereafter, the Legal Department would then review this report and make recommendations for the outcome. It is important to bear in mind that there may be more than one possible outcome at the end of an investigation, depending on the circumstances. So let's examine each of these in further detail. No further action. Where based on the findings of the investigative report, the legal department is of the view that there is insufficient evidence to substantiate the allegations made, they may recommend that the matter should be closed. For example, the complaint may have been based on an allegation of bid rigging. However, the evidence obtained in the investigation may not establish the different elements of the offense that we discussed earlier in this webinar. In the process of review, the legal department would assess the reliability, credibility, and sufficiency of the evidence obtained to ensure that it meets the appropriate standard for action to be taken. Furthermore, where the evidence assessed cannot be strengthened by further investigation, after all reasonable lines of inquiry have been pursued, there will be no further action taken. Where this decision is made by the OPR, the parties would be informed accordingly. So according to Section 44 of the Act, The office is empowered to make recommendations to designated parties after an investigation is conducted. This section states that after conducting an investigation, the office shall, without delay, in writing, inform the affected parties and the minister, the chief secretary, or the public official having responsibility for that body of the result of that investigation and make such recommendations as it considers necessary in respect of the matter which is investigated. You may notice that this section is similar to the power conferred to the Ombudsman under Section 96(2) of the Constitution to provide reasons to the complainant and to inform the government department concerning the outcome and to make such recommendations as he sees fit. In fulfilling this duty under Section 44, the OPR will consider the specific facts and circumstances of the complaint and provide recommendations that are targeted and relevant to the public body or person under investigation. These recommendations will be based on the Act, the regulations, and the handbooks and guidelines and best practices in procurement, disposal, and retention. This is an important aspect of the complaints process as it provides the OPR with the opportunity to give guidance to public bodies in the face of a complaint. Parties are therefore able to learn from their mistakes and minimize such occurrences in the future. Next, we're going to discuss the notice of adverse report and opportunity to be heard in accordance with Section 48. This section states that the office shall not make a report which concludes that a public body or person has failed without reasonable justification to fulfill a duty or obligation under this Act, unless reasonable notice has been given to the public body or person of the alleged failure and the public body or person has been allowed a full opportunity to be heard, either in person or by an attorney at law. Essentially, where the findings of an investigation establish some level of wrongdoing or failure to comply with the Act on the part of a public body or person, this section imposes a duty on the OPR to present those specific allegations and findings to the public body or person so that they may provide a response before the OPR makes a final determination into the matter. It gives any person or public body under investigation a reasonable opportunity to put forward any explanations, evidence, or arguments, or any defense that they wish to make in the face of the adverse findings. A failure on the part of the OPR to properly observe this duty can jeopardize any investigation conducted and can also expose the office to civil liability. Some of you may recall that in the year 2004, the Integrity Commission commenced an investigation against a member of Parliament in relation to siphoning of materials from the Scarborough General Hospital site in accordance with the Integrity in Public Life Act. The Integrity Commission was bound by a similar duty to give notice of adverse findings, but failed to afford the Member of Parliament an opportunity to respond to the allegations against him before it concluded its report and issued same to the Director of Public Prosecutions for action. In 2009, a High Court judge found that the Integrity Commission acted in bad faith and was guilty of misfeasance in public office and was ordered to compensate the Member of Parliament in damages. This provision, outlined in Section 48 of the Act, ensures that the OPR observes the rules of natural justice and procedural fairness in its investigative process. It is a common provision which is featured in the legislative framework of regulatory bodies. So by way of comparison, it is very similar to Section 3, subsection 1 of the Ombudsman Act, which requires that the Ombudsman afford the party under investigation an opportunity to be heard and to make representations before it makes any report which may adversely affect that person. So ultimately, these procedures inspire trust and confidence in the OPR's complaint process. The final outcome that we're going to discuss today is Section 45, under which the office is empowered to make a report to the Director of Public Prosecutions. So this section states where, after the conduct of an investigation, the office is satisfied that there are reasonable grounds for suspecting that an offense has been committed, it shall make a report to the DPP, who may take such actions as he thinks appropriate. So if you look through the Public Procurement and Disposal of Public Property Act, you will see that there are provisions which establish criminal offenses. Earlier in this webinar, my colleague would have outlined some of the offenses and the penalties that accompany them. And you will notice that these are criminal offenses. The Office of the Director of Public Prosecutions is the body authorized by the Constitution to prosecute these criminal offenses. The decision to invoke Section 45 of the Act is a serious step that affects the subject of the investigation, as well as witnesses, and the Office of Procurement Regulation understands that it must be taken with utmost care. It is for this reason that we, the OPR, must be satisfied that on an objective basis or an objective assessment of the evidence, that there are reasonable grounds to suspect that the person in question has committed the offense. So you might be wondering, what does reasonable grounds mean in accordance with Section 45? Reasonable grounds can mean a finding based on reliable information that goes beyond just a mere suspicion or allegation. The decision to report to the DPP must consider the impact of any defense or information that the subject of investigation has put forward or on which they might rely, and all of the material information available. So in relation to this point, you would recall that a short while ago, we looked at the importance of Section 48 and the importance of giving a person or a public body under investigation an opportunity to be heard and put forward any evidence or arguments that they may wish to do. Where the reasonable grounds threshold has been met, in accordance with Section 45, the OPR must report the matter to the DPP. It is important to remember that the Director of Public Prosecutions will have the final say in whether or not criminal proceedings are in fact initiated. However, the OPR will maintain a line of communication with the DPP's office in relation to any matter which has been reported to it. So now that we've spoken extensively about the OPR's complaints process, we would just like to share with you the OPR's whistleblowing solution and to take some time to distinguish that whistleblowing solution with the OPR's Part 4 complaints process. So the OPR has a whistleblowing solution, which is a platform managed by an independent and external third party to receive whistleblowing reports. It is developed and based on the OPR's whistleblowing policy, which is influenced in large part by the OPR status as a designated authority in the Whistleblower Protection Bill 2018. That version of the bill, the 2018 version, was not passed, but it was since relayed in Parliament in the year 2022. As you would be aware, it is not yet enforced as the parliamentary process is still ongoing. So in accordance with the OPR's whistleblowing solution, the OPR can receive and investigate reports of improper conduct. And now we're going to compare and contrast the Part 4 complaints process with the OPR's whistleblowing solution. So the first thing we're going to look at is who can submit a report under each of these streams or systems, as you may call them. So under Part 4 complaints, you've heard earlier in this webinar that any member of the public can make a complaint, and this can include a contractor, supplier, or a public servant. Under the whistleblowing solution, members of the public may also make complaints, but you would notice that employees of the OPR or a member of the board of the OPR can also make a report under the whistleblowing solution. Next, we're going to speak about what can be the subject of a report. So for Part 4 complaints, we examined earlier the 3 categories of complaints that can be made. These are an irregularity in procurement proceedings, bid rigging or other forms of collusion, and any alleged breach of the Act. For whistleblowing reports, these reports can be made in relation to what is deemed improper conduct, which is conduct that can result in a miscarriage of justice, is likely to threaten the health and safety of persons, or shows discrimination. It can also refer to an irregularity in procurement proceedings. So as you can notice from these definitions, there are some similarities. However, the category of what can be reported under the whistleblowing solution is much broader than what can be reported as a complaint under Part 4 of the Act. How can a report be made? My colleague earlier in this webinar would have explained to you the use of the OPR's complaint form and the way in which it can be submitted via any of the 3 channels, which are online, mail-in, or walk-in submission. For the OPR's whistleblowing solution, on the other hand, these reports can be made online, the Integrity Count platform, or via the OPR's toll-free hotline. And these are, as I've said before, administered by an independent external third party. Next, you may be wondering, do I have to reveal my identity? So for Part 4 complaints, yes, it is necessary to reveal your identity, as you are required to provide valid contact information on the OPR's complaint form. On the other hand, for whistleblowing reports, it is not necessary to reveal your identity, as you are allowed to submit anonymous reports, and revealing your identity is optional. Am I protected? We spoke earlier today about the protection afforded to complainants in accordance with Section 40 and Section 47 of the Act, which criminalizes victimization of persons who make complaints, as well as safeguarding a person from being accused of breaching a duty if they choose to make a complaint to the OPR. For whistleblowing reports, unfortunately, due to the status of the legislation, the extensive protections in the Act are not yet afforded. However, the OPR will, in accordance with Section 40 and 47, afford the same protection to persons who make reports under the whistleblowing solution. How are my reports handled? For Part 4 complaints, the investigation report will be reviewed by multiple persons within the OPR before a final determination is made, and we discussed that process earlier today. For whistleblowing reports, the report will be handled by a whistleblowing reporting officer and the whistleblowing reporting committee before a final determination is made. Finally, what are the potential outcomes? For Part 4 complaints, we spoke about the outcomes after an investigation, which can include a report to the DPP where reasonable grounds for suspecting that an offense has been committed, or recommendations to the parties. For whistleblowing reports, wrongdoing will be reported to the appropriate body so that corrective action can be taken, including, where appropriate, reporting these to a law enforcement authority. So just a final note on the whistleblowing solution of the OPR, you would notice that even though there are some similarities between these two platforms, there are notable differences, and the OPR is mindful of the fact that reports about breaches of the Act can be received through the OPR's whistleblowing solution. However, once these reports of breaches satisfy the requirements of Section 41, they will be investigated in accordance with the procedures of Part 4 complaints that we discussed earlier in this webinar. So to conclude the complaint segment of this webinar, we're just going to speak about some frequently asked questions concerning complaints. The first is, how does the office deal with misleading complaints? Within the Act, it is an offense to knowingly or mischievously make a false report to the office, to mislead the office by giving false information, or to make false statements or accusations. So this is an offense which attracts a penalty of a fine of $500,000, as well as imprisonment for 1 year if the person is found guilty of this conduct. Next, can I make a complaint on behalf of someone? Yes, this is allowed. You are allowed to make a complaint on behalf of another person. However, if you are making a complaint on behalf of someone else, you must ensure to include all pertinent information in the complaint form. Next, can I withdraw my complaint after it has been filed? Yes. Where you wish to withdraw your complaint, however, you will be encouraged to communicate this decision to the OPR in writing. The OPR will consider whether this matter is one to be investigated on the OPR's own initiative, notwithstanding that you have chosen to withdraw your complaint. How long does the office take to investigate a complaint? Within the Public Procurement and Disposal of Public Property Act, there isn't a fixed deadline for investigating complaints. However, the office undertakes to ensure that all complaints are dealt with and investigated in a timely manner, and will endeavor to avoid unreasonable delay in all circumstances. What is the consequence of withholding or concealing information? This type of behavior is an offense. It is an offense to withhold, conceal, or destroy or refuse to produce any books, documents, or records that are required for the purpose of an investigation under this Act. Any person who engages in such activity is in breach of the Act, and such breach may be investigated by the office. If convicted, this attracts a penalty of $5 million in the form of a fine and 10 years imprisonment. And last frequently asked question, will my complaint be kept confidential? Yes, all complaints made to the OPR will be kept confidential. However, it will only be disclosed in the following situations. Firstly, where it is necessary to progress the investigation to the complaint. Secondly, pursuant to the terms of a court order. Or thirdly, where the disclosure is required by a law enforcement authority or the Office of the Director of Public Prosecutions.
Good afternoon, colleagues. So we will take you through the challenge proceedings and the ineligibility proceedings. So of particular interest for some of the attorneys at the Office of the Ombudsman will be the challenge proceedings. And you may ask yourself, why challenge proceedings? What is the importance of this particular part in the said legislation? Also, you all might have heard maybe some discussion in the public domain as it pertains to these challenge proceedings may stymie the procurement process. Or you might have maybe heard other things regarding the whole challenge proceedings and how will it operate under this particular new procurement regime. So we will set out for you what are the challenge proceedings and why it is so important, this particular part 5, why it's so important for any effective procurement system. And I will just set some context for you in terms of why this particular Part 5 challenge proceedings is so important to this piece of legislation. Now, our legislation was modeled against the UNCITRAL model law, and that is the United Nations Commission on International Trade Law. And of particular importance, we would want you to note that a key feature of any effective procurement system is the existence of a mechanism to monitor that the system rules are followed and to enforce them if necessary. So such a mechanism includes not only our power as the office possessed under Section 13, audits and investigations. We also have the power of prosecution for criminal offenses, but we also have these challenge proceedings or procedures in which suppliers and contractors are given the right to challenge decision and actions of the procuring entity that they allege are not in compliance with the rules contained in any applicable procurement legislation. So another thing we would look at is to have an effective challenge mechanism. It also helps to make the Act an important degree of self-policing and self-enforcing, since it provides an avenue for suppliers and contractors that have a natural interest in monitoring procuring entities' compliance with the provisions of the Act in each procurement procedure. And it also helps foster public confidence in the procurement system as a whole. And an additional function of this whole challenge mechanism as well is that it also acts as a deterrent. Its existence is designed to discourage actions or decisions knowingly in breach of the law. And for these reasons, a challenge mechanism is an essential element of ensuring the proper functioning of any procurement system, and it will promote that confidence in the system that we require and we aim for. So I'll take you through the attorneys will want to have a particular interest in this part as well as the ineligibility proceedings. So we will take you through the slides and an overview of this particular part. We will touch on what are challenge proceedings, who hears and determines challenge proceedings, what are the governing laws and rules for challenge proceedings, what can be challenged, what are the time frames for submitting an application for review? The standstill period, and Melissa would have touched on that earlier on. The 20-day process for challenge proceedings. Things to remember, and can the decision of the hearing panel be appealed? Right, sorry about that, colleagues. So we will continue. What are challenge proceedings? So as I said earlier, we would have Melissa touched on the objectives of the Act, and one of the mechanisms as well built in the Act for carrying out its objectives is these challenge proceedings. And the challenge proceedings is a process by which a supplier or contractor, that is the applicant, may apply to the office for a review of a decision or action taken by a procuring entity. The procuring entity in this case is the respondent in a procurement proceedings. Now, pursuant to Section 49(1) of the Act, and Melissa touched on this earlier, a supplier or contractor may bring challenge proceedings where it is alleged that a procuring entity made a decision or took action that is not in compliance with this Act, and B, the supplier or contractor has suffered or is likely to suffer loss or injury because of the decision or action of the procuring entity. Now, you will note that the use of the word "and" in order to bring the challenge against the decision of the procuring entity, the supplier or contractor must satisfy both A and B. So who hears and determines challenge proceedings? The office has established a hearing tribunal to hear these challenge proceedings. The hearing panel will comprise of members of the board and management of the office of no less than 3 and no more than 5 who are selected by the office for their competence in the specific areas of dispute. One of these members will also be appointed to chair the hearing. So what are the governing laws and rules for challenge proceedings? And in order to resolve the applications brought before the tribunal, and in keeping again with the objectives of the Act, all concerned should be aware of and abide by the governing law and rules for challenge proceedings. These governing laws and rules are Part 5 of the Public Procurement Disposal of Public Property Act, number 1 of 2015 as amended. Of particular note is the regulations, the Public Procurement and Disposal of Public Property Challenge Proceedings Regulations 2021. We also have the hearing rules and procedures for Part 5 of challenge proceedings and the electronic filing and hearing rules for Part 5 challenge proceedings. The Act and regulations can be found on our website. The hearing rules and electronic rules will be uploaded in short order. So let us move to how can you initiate challenge proceedings. So a supplier or contractor who has suffered or is likely to suffer loss or injury because of the decision or action taken by a procuring entity in procurement proceedings which are not in compliance with the Act can initiate the process. So only we have the supplier or contractor. And to do so, the supplier or contractor must submit an application for review to the office, and that is further to Section 51 of the Act. Now, when making the application, one would be required to outline the basis of the challenge. So let us now look at what can be challenged. So as stated earlier, suppliers or contractors can challenge decisions or actions taken by procuring entity in the procurement proceedings that are not in compliance with the Act. As such, challenges can relate to 4 particular circumstances, and we have some examples to share with you. Namely, 1, we have the terms of pre-qualification or decisions or actions taken in pre-qualification proceedings. And an appropriate example that we wish to draw to your attention is where a failure to respond to a supplier's request for clarification of the pre-qualification documentation within a reasonable time to enable the supplier to present an application in a timely manner. Another appropriate example is under the ambit of the terms of pre-selection or decisions or actions taken in pre-selection proceedings. An example here is where maximum number of contractors to participate in a procurement activity specified and the supplier is not listed without any proper justification or the maximum number is exceeded. The third circumstance relates to the terms of solicitation, and here the example is where the terms of reference or specification favors one supplier, product, or brand. And fourthly, other decisions or actions taken in a procurement proceeding, for instance, accepting late bids without proper justification and without notifying the other bidders. So please note that these challenges must be filed before the timeframes specified in Section 52. So what are these timeframes? In the first 3 circumstances mentioned in the previous slide, where the challenge relates to, we had pre-qualification, pre-selection, or solicitation, or decisions or actions taken by a procuring entity in pre-qualification or pre-selection proceedings, the deadline to file this challenge is prior to the deadline for presenting submissions. Where, however, the challenge relates to other decisions or actions taken by a procuring entity in procurement proceedings, the deadline to file this challenge depends on whether or not a standstill period was applied by the procuring entity. Now, we touched on standstill, that is Section 35(2) of the Act earlier on. Melissa touched on it. And if a standstill period was applied, the deadline to file this challenge is within the standstill period. If, however, a standstill period was not applied, the deadline to file this challenge is within 7 working days after the publication of the notice of a decision or action that was taken by the procuring entity. So some of you may be wondering exactly what is this whole standstill period is about. So this diagram here illustrates the standstill period process. The standstill period is a short pause, as Melissa said earlier on. It is 10 to 15 working days in duration, which begins when the notice of a decision to award is issued to participating suppliers or contractors. In the procurement cycle, the standstill period occurs before issuing the notice of acceptance to the successful bidder. And again, according to Section 35(2), a procuring entity shall promptly notify each supplier or contractor who presented submissions of its decision to accept the successful submission at the end of the standstill period. Now, the duration of the standstill period is calculated based on the form of communication the procuring entity intends to use to transmit the standstill notice to the suppliers or contractors. A 10-day standstill period is to be used if the notice is to be dispatched via email, and usually if it's 15 days where the notice will be sent via letter, mail, or reliable courier. Now, the standstill period begins at 1 minute after midnight on the day of dispatch of the notification of decision to award and ends at midnight on either the 10th working day after the notice is communicated electronically or the 15th working day from the date of sending the notice via letter, mail, or a reliable courier. Now, in this particular example here, the standstill duration is 10 working days. The minimum requirement of the Public Procurement and Disposal of Public Property Evaluation Regulations 2021. Now, if no application for review or challenges are made within the 10-day period in this example, then the procuring entity is free to award the contract or framework agreement. If, however, an application for review or challenge is received by the office, however, this initiates the application for review and the challenge proceedings, and the procuring entity will therefore not be able to award the contract or framework agreement until the proceedings are completed or it is granted permission to do so by the hearing panel. So my colleague, Ms. Maharajh, will take you through the other slides as we go into the particulars. We drill down further into the 20-day process and the challenge, continue with the challenge proceedings.
Thank you, Ms. Mitchell. So I will now take us through the challenge proceedings process at the office, which starts from the moment an application for review is submitted and ends when the final decision is made by the hearing panel. As you can see, it is referred to as the 20-day process. This is because Section 50, subsection 11 of the Act stipulates that a decision of the office shall be issued within 20 working days after receipt of the application for review. The office is required to give all its decisions and actions in writing and will provide same no later than 30 working days after the making of its decision in accordance with Section 50, subsection 12 of the Act. As we will continue to see in the following slides, there are steps to be taken by the parties and the office each day of the process in order to achieve completion and decision by day 20. The office would therefore be constrained to maintain the time frames in this process, and requests for extensions of time at various junctures may rarely be accommodated. Please note that on the days not specifically highlighted in our presentation today, the office will be conducting its internal preparations for the hearing or other deliberations to determine the matter by day 20. So now let's turn to the first 3 days of the process. Day 1. This begins with the submission of an application for review to the office by an applicant. The applicant is a supplier or contractor who participates in procurement proceedings that are being conducted by a procuring entity and satisfies the requirement of Section 49 of the Act as addressed by Ms. Mitchell. In terms of the procedural aspects of the documents and communications involved during the challenge process, in an effort to maintain simplicity and uniformity in the process, the office has created prescribed forms which are to be used throughout the proceedings. So, for example, the application for review is Form 8. Additionally, the office has created an email platform to receive submissions by the parties to challenge proceedings upon proclamation of the Act. The email address to be used is challenge@opr.org.tt, and it will be the medium through which the OPR officer who is designated as the hearing secretary will communicate with the parties and vice versa. When a document is submitted through this email platform, the hearing secretary will subsequently email a stamped copy of that document to the party that submitted it. This indicates that the document has been filed with the office, and the stamped document now has to be served on the other parties to the proceedings. So once an application for review is received on day 1, the office will take the following steps within the first 3 days. Firstly, it will publish a notice of the application in 2 daily newspapers and on its website. And secondly, it will notify the procuring entity of the application via email to the accounting officer equivalent and the named procurement officer. For this reason, it is of utmost importance that procuring entities provide up-to-date information on the names and email addresses of these office holders and promptly notify us of any changes. Let's now take a closer look at Form 8, the application for review. So if you can give us a moment for us to toggle to the next slide. So this is a snapshot of what the Form 8 application for review looks like. The forms will be posted on the OPR's website shortly, so you can download and familiarize yourself with the information to be provided to the office. We will now look at some of the key details of this form. So the applicant will have to provide some of the following key information. Each decision or action of the procuring entity which is being challenged and the date of that decision or action. The facts surrounding each decision or action so that the office can have a context of the events. These include details of solicitation documents, the goods, works, or services being procured, the deadline for submissions, details on standstill periods implemented as may be applicable. The applicant must also state the grounds or basis for the office to review the decision or action by the procuring entity. That is, the applicant has to show what is the non-compliance or breach being alleged. If multiple decisions or actions are being challenged, the grounds for review of each decision or action must be stated. Fourthly, the remedies that are being sought from the office in keeping with the office's powers under Section 50, subsection 10. For example, the applicant may seek the overturning of the award of the contract or framework agreement, or even the termination of procurement proceedings or bid preparation costs, or costs relating to this application for review. The applicant must also list the witnesses he will be presenting on his behalf at the hearing in support of the facts and matters stated in the application for review. The applicant must also state efforts taken to resolve the issue directly with the procuring entity. The office encourages parties to dialogue before the matter is escalated to the point of filing an application for review. The issue may be easily resolved, for example, where there's a simple mathematical error in the tallying of evaluation scores, and engaging in dialogue can avoid the initiation of challenge proceedings and consequential costs and delay in procurement process. Applicants are therefore encouraged to engage with the procuring entity first to clarify or lodge a complaint. And similarly, the procuring entity must respond to such requests for clarification or such complaints in a diligent manner. Details of this dialogue can be provided and attached to the Form 8 if the matter is not resolved with the procuring entity. However, suppliers and contractors would have to be mindful of the time frames to file their application for review, as we saw in the previous slides, and ensure that the application is filed if the matter remains unresolved as the deadline approaches. A point to note is the office has prepared instructional guides on how to complete all the prescribed forms to assist the parties to challenge proceedings, and these too will be uploaded to our website shortly. Turning to the documents to be provided in support, Form 8 lists the following examples of information that can be attached depending on their relevance to the matters raised in the application for review. These supporting documents include invitation to bid, or if there was a request for proposal or quotation, invitation for pre-qualification or pre-selection, notice of intention of award that was issued by the respondent, which would be the procuring entity, the bid that was submitted by the applicant bringing a challenge, any requests for clarification that would have been sent by the applicant, correspondence between the applicant and respondent in relation to efforts taken to resolve the matter directly with the respondent, any emails, correspondence, or other documents that are relevant to the decision or action being challenged. It should be noted that not only are these supporting documents to be listed in the Form 8 itself, but copies of the said documents must also be attached. Failure to attach any relevant documents can result in the inability of the applicant to rely on these at the hearing. It should also be noted that Form 8 allows redaction of information relating to categories set out in Section 52 of the Act. This information, if disclosed, falls in the following categories. So information which, if disclosed, would A, impair the protection of essential security interests of the state, or B, be contrary to law, C, impede law enforcement, D, prejudice the legitimate commercial interests of suppliers or contractors, or E, impede fair competition. The office intends to issue guidelines on how redaction pursuant to Section 52 should be undertaken. So you can see how much information is required from the applicant from very early in the process. This front-end loading, so to speak, is to enable the office to be apprised of all the material facts and matters as early as possible, so that the challenge process can be completed within the statutorily imposed 20-day deadline. When Form 8 and supporting documents are submitted to the office, the hearing secretary will subsequently email a stamped copy of the document to the party submitting it. This indicates the document has been filed. The filed version of all documents bearing the OPR stamp must be served on the procuring entity. Once served, Form 1, confirmation of service, must be submitted to the office through the same email platform, that is challenge@opr.org.tt, with the case reference number stated in the subject line. If there was personal service, a copy of the endorsed document must be attached to the Form 1. This is the copy where the person receiving the file document signs and dates the first page showing that the original was received. If there was electronic service, a copy of the email showing the electronically delivered document must be attached to Form 1. This confirmation of service Form 1 has to be submitted through the email platform when file documents are served on other parties throughout the proceedings. Another form the applicant should be aware of at this early stage is the Form 2 Notice of Appointment of Representative. A party can engage a representative to act on its behalf during the proceedings. and the representative can be an attorney at law or such other suitably qualified and experienced person, which may include but not limited to an engineer, quantity surveyor, valuator, agent, or such other person as shall be recognized by the office for the purpose of representation in accordance with Regulation 7 of the Challenge Proceedings Regulations. Where a representative is engaged, this form too must be filed with the office and served on other parties. Turning to days 4 to 6 now, as shown in this slide, there are 4 main activities highlighted during this period which the applicant should be aware of. These relate to suspension, dismissal, the reply, and the application to participate. Let's first look at the issue of suspension. Section 54 of the Act empowers the office to suspend either the procurement proceedings before the entry into force of the procurement contract, or the office can suspend the performance of a procurement contract or the operation of a framework agreement that has already been entered into force. The office can determine the length of suspension for as long as it finds necessary to protect the interests of the party. This power of suspension may be exercised by the office within 3 days of receipt of the application for review. The office will notify the parties of its decision on suspension between day 4 and 5. Reasons for the decision will be provided by day 7 in accordance with Section 50, subsection 6 and subsection 7. The second area highlighted in this slide is the issue of dismissal of the application. Regulation 4 empowers the office to dismiss an application for review and lift any suspension that is in effect in 3 circumstances, namely, where the office is of the opinion that the application is manifestly without merit, or where it was not presented in compliance with the timeline set out in Section 52 of the Act, or where the applicant has not demonstrated sufficient standing by way of either pecuniary or otherwise economic interest in the procurement proceedings. Where the office exercises its power to dismiss the application in those circumstances, it will promptly notify the applicant, the procuring entity, and all qualified suppliers and contractors in the procurement proceedings of this dismissal and reasons for same. The third and most important activity from the perspective of a procuring entity during this period of the 20-day process is the submission of the reply. Under Regulation 9, subsection 1, within 3 working days of receipt of the notification that an application for review was submitted to the office, the respondent must submit a written reply and documentary evidence in support to the office. Transcribing this time frame within the 20-day process, it means that the latest day for the submission of the reply and supporting documents is day 6. We will go into details of the reply and supporting documents in the following 2 slides, but there are 2 things to be highlighted at this point. Firstly, as stated earlier, a party can engage a representative, and where the representative is engaged by the respondent, Form 2, Notice of Appointment of a Representative, must be filed on the office and served on other parties. The second point to note is that under Regulation 9, subregulation 5, the respondent may request that the office authorize it to award a procurement contract or enter into a framework agreement on the grounds that 1. A delay in awarding the procurement contract or entering the framework agreement would be contrary to public interest, or 2. Such other consideration which would justify awarding the procurement contract or entering the framework agreement while the office conducts its review. Where the office requests such authorization, the grounds being relied upon must be substantiated by evidence in support and be provided to the office for its consideration of this request. This request may be submitted to the office at the time the respondent provides its written reply to the office. The fourth activity during days 4 to 6 to be aware of is that interested parties can apply to participate in ongoing challenge proceedings by submitting a Form 10, Application to Participate. This is to be done by day 6. An interested party is someone falling in the category set out in Section 51(1) of the Act. That is, any supplier or contractor who participates in the procurement proceedings to which the application for review relates, or any public body whose interests are or could be affected by the application for review. Some points to note for suppliers and contractors joining ongoing proceedings are as follows. The interested party is restricted to the grounds of challenge and remedies contained in the applicant's application for review, and the supplier contractor who participated in the same procurement proceedings that are under review, but he wishes to raise other grounds of challenge or seek remedies specific to him, he would have to file his own application for review within the timeframe set out in Section 52 of the Act. And thirdly, interested parties will have to bear their own costs for participating in an ongoing challenge proceeding. The next slide shows a snapshot of what Form 9, the reply, looks like. The key information to be filled out by the respondent in Form 9 is as follows. The email address of the named procurement officer, and if a representative retained that person's email and contact details. Reply to the facts concerning the decisions or actions being reviewed. So this section gives the respondent an opportunity to state the pertinent background facts and matters about the procurement proceedings and the decision or action that the applicant is challenging. Thirdly, verification or other response to the information provided by the applicant and particular sections of Form 8. So, for example, the respondent has to indicate whether the applicant accurately stated the tender number, date of issuance of the solicitation document, the deadline set by the respondent for presenting submissions in response to the solicitation documents, or the length of the standstill period if one was applied. If the information provided by the applicant is inaccurate, the respondent has an opportunity to indicate the correct information and attach relevant documents in support. Fourthly, the respondent has an opportunity to reply to each ground of review for every decision or action that is being challenged by the applicant. The respondent must also state any facts or matter which is relevant to the release of remedies sought by the applicant. Similar to the applicant, the respondent has to indicate the names of all persons that it intends to call as witnesses at the hearing in support of the facts and matters stated in their reply. Efforts taken to resolve the issue with the applicant must also be outlined. Finally, it is important to note that Form 9 must be signed by the accounting officer or its equivalent as stipulated in Regulation 9(1)(a). As a point to note, the office has prepared instructional guidelines as stated before, and these will be uploaded shortly for your perusal. Turning to the documents to be provided in support, Form 9 lists similar information that can be attached as indicated above, the invitation to bid, etc. And just to reiterate, failure to attach any of these documents can result in the inability of the respondent relying on these at the hearing. Furthermore, Regulation 9(1)(c) stipulates that the respondents must submit any document referred to in the application for review which is in its possession but not available to the applicant. It should be noted that Form 9 equally allows redaction as mentioned before. This slide demonstrates what actions the OPR's hearing panel can take if the respondent fails to submit a reply. If there is no good cause for failing to submit a reply, Regulation 9.4 states that the office may proceed with its deliberations on the basis of the evidence before it, as if such proceedings had been conducted in the presence of all parties. This means that the office can make decisions requiring certain actions it considers appropriate in the circumstances to be taken, and this would be pursuant to Section 50(10) of the Act. Furthermore, the respondent shall be bound by any decision of the office as stated in Regulation 9.2 of the Challenge Proceedings Regulations. During days 8 and 9, the office will provide the parties with the following information when necessary. Firstly, a notice of a case management conference, CMC, which will state the following key information: the date, time, place, and purpose of the CMC, whether the parties are required to attend in person, that they may be represented through a representative, but that person must have the authority to make agreements and give undertakings on behalf of the party at the CMC. The notice of CMC will also state that if a party does not attend, either themselves or through a representative, the presiding member of the hearing panel may proceed in their absence, and that binding orders would be made by the hearing panel with respect to the continued conduct of the challenge proceedings. Secondly, if the respondent requested authorization to award a procurement contract or enter into a framework agreement, the decision on this request would be provided. Thirdly, if an interested party submitted an application to participate, the decision on this application would also be provided between days 8 and 9, as well as decisions on any other applications which were previously supplied. It is also of note that if a party seeks to have an expert provide evidence at the hearing, an application for leave or permission to call expert evidence must also be filed between days 8 and 9. We will now take you through this area of expert evidence. Slide is showing a snapshot of what the application for leave to call expert evidence, which is our Form 11, looks like. So now we will turn at some key details of the form. So the first point to note is that the party must first seek permission or leave of the hearing panel to call or adduce expert evidence at the hearing. Expert evidence must be reasonably required to resolve the challenge proceedings justly and in accordance with the overriding objective of the hearing rules and procedures for challenge proceedings. What is this overriding objective, you may ask? Well, the overriding objective is to enable the hearing panel to deal with cases fairly and justly, having regard to various considerations such as dealing with the case in ways which are proportionate to the importance of it, the complexity raised, and the anticipated costs and resources of the parties, and as well avoiding delay so far as compatible with the proper consideration of issues to be determined in challenge proceedings. Details to be included in Form 11 include the name, address, and qualifications of the proposed expert, issues on which the expert will provide evidence, the substance or summary of the relevant points of the expert's evidence, list of documents to which the expert may refer to, as well as the grounds for the actual application for permission to call this witness as an expert. We will now turn to day 11 of the 20-day process. Day 11 is the day scheduled for the CMC. At this conference, the hearing panel can make orders with respect to the conduct of challenge proceedings after giving parties an opportunity to make representations. Some examples of such orders are simplification or clarification of the issues, disclosure of documents, facts or evidence that may be agreed upon, preliminary matters, skeleton submissions, rescheduling of the hearing, and resolution of any or all of the issues presented in the challenge proceedings. By day 11, the parties must also inform the office if any of the following situations apply. Firstly, if the assistance of an interpreter is required, this has to be done through submitting a Form 6, Notice of Requirement of an Interpreter. It should be noted that arrangements to retain and utilize the services of an interpreter is to be borne by the party submitting the notification to the office. Secondly, by day 11, parties must inform if accommodation is required for differently abled persons to attend a physical hearing, and that is to be done through Form 7, Notice of Requirement of Accommodation. Turning to days 12 to 13, the office will provide a notice with the directions or orders made at the CMC, as well as provide the parties with the date, time, and place of the hearing. The party requiring the assistance of an interpreter must also submit the qualifications of the chosen interpreter to the office during this 12 to 13-day period. And all parties must file and serve their respective witness statements, expert evidence if applicable, and skeleton submissions within these 2 days. Let's now look at the details to be provided in a witness statement. From the perspective of the respondent, the witness statement must provide an account of the facts in support of the claims contained in the reply. It can refer to and attach any relevant supporting documents. Note, however, that these documents must have been attached to the Form 9 reply at the beginning of the proceedings. The witness statement must also include a statement that the matters set out are within the witness's own knowledge except where otherwise indicated, and that the contents are true and correct. And finally, the said statement must be signed and dated by the witness. A party who fails to provide a witness statement in accordance with the hearing rules and procedures for challenge proceedings may not call the person as a witness without leave or permission of the hearing panel. Where expert evidence is allowed by the hearing panel, the expert witness must provide independent assistance to the hearing panel by way of objective, unbiased opinion in relation to matters that are within his expertise, and he must follow the guidelines contained at Schedule 1 of the Hearing Rules and Procedures for Challenge Proceedings. Some of these guidelines are that the expert evidence must not change his opinion or withhold information to suit the position of the party that has retained or employed him. And the expert has certain duties of disclosure, such as the responsibility to make full and fair disclosure, making it clear when a particular question or issue falls outside of his expertise, and that where the opinion and evidence are based on information contained in other documents, detailed references should be provided in any report prepared by the expert, and copies of those documents must be attached to his report. Turning to skeleton submissions now. These are a summary of the arguments in support of the responses in the reply in relation to the allegations that the respondent made a decision or took an action not in compliance with the Act, and that the applicant has suffered or is likely to suffer loss or injury because of the said decision or action. So in essence, the skeleton submissions provide the framework for the oral closing submissions of the respondent at the hearing. Now, day 14 is not highlighted in this slide as the procuring entity is not required to file any documents, but all parties and the hearing panel will be preparing for days 15 to 16, which is the days assigned for the hearing of the application for review. Some points to note about the hearing. All parties are required to attend. Non-attendance will not prevent the hearing panel from continuing with the hearing in that party's absence, where the panel is satisfied that the notification of the hearing was received and the party is absent without good cause. At the hearing, the applicant will present its case and call witnesses who can be questioned by other parties and the hearing panel. The respondent and interested parties, if any, will follow the same process. Each party will then be given the opportunity to make oral closing submissions to the hearing panel. It should be noted that the hearing is the latest time at which an applicant can make an application for course Form 15 in accordance with the hearing rules. If such an application is made, the respondents will be given an opportunity to make representations on same. After the hearing, the panel will meet between days 17 to 19 to deliberate on the evidence provided. It will formulate its decision by day 20 as stipulated under Section 50(11) of the Act, and immediately thereafter communicate its decision to all parties and other participants in the procurement proceedings. All persons shall comply with the decision and directive of the office. Written reasons will be provided no later than 30 days after the decision in accordance with Section 50(12) of the Act. If the procurement proceedings were suspended, this order of suspension shall be lifted immediately upon the issuance of the decision of the hearing panel on day 20. By day 30, parties can apply for the record of hearing via Form 16, and this record will be in an electronic format. This brings us to the end of the 20-day challenge proceedings process. Turning to a few things to bear in mind as you go through the challenge process. Firstly, every application will be assigned a specific case reference number upon the initiation of these proceedings. That is, when the applicant submits his application for review, the office will issue an email indicating the case reference number assigned. The email the office sends to the accounting officer equivalent and the NPO informing of the filing of the application for review will state the case reference number. This number must be stated at the beginning of the subject line in all emails or correspondence that is submitted to the office thereafter, and it must also be included in any other forms filed with the office. The number must be reproduced in the identical format issued, that is, without any spaces or characters in between. Secondly, once documents are stamped as being filed, the office will email them to the filing party, who must then serve the stamped versions on other parties to the proceedings. When this is done, the confirmation of service Form 1 must be submitted to the office. Also note that documents submitted to the office for filing must be emailed between the hours of 8 a.m. and 4 p.m. on working days. Where documents are sent outside the prescribed time without the permission of the hearing panel, the sender will receive an email from the office stating that his email will be returned and must be filed within working hours on working days. If documents are submitted on public holidays, the filing date will be stamped as the next business day. You will recall that during the 20-day challenge process before the office, a decision can be issued relating to the suspension of the procurement proceedings by day 3. And then the final decision on the substantive matter will be issued by day 20. If a party is dissatisfied with and has an interest in these orders or decisions, he can appeal to the Public Procurement Review Board by requesting a review of the decision of the office. This review mechanism is provided for under Section 51A to L of the Act. A request for review to the review board must be made within 21 days of receiving the order or decision of the OPR's hearing panel. The review board may dismiss a request for review that it believes is frivolous or vexatious. Within 21 days of receiving the request, the review board must meet to conduct a review, and that review process must be completed within 28 days. The review board can take two broad forms of actions upon completion of the review. Namely, it can confirm, vary, or overturn the decision of the OPR's hearing panel. And 2, it can order the payment of costs as between the parties to the review. If a party still feels aggrieved at this stage, they can subsequently appeal against the decision of the review board to the High Court within 28 days of the making of that decision. So this brings us to the end of the formal presentation on the challenge proceedings process before the OPR and the appeal mechanisms thereafter as contained in the Act.
At the ineligibility proceedings. So as we refer to these proceedings as streams, so we touched on complaints, we touched on challenge, and we're touching now on the third stream, which is the ineligibility proceedings. And again, this is another mechanism that acts as a checks and balance on any procurement system, any effective procurement system, and that is to protect the integrity, again, of the system, to prevent fraud, waste, abuse, and to address issues regarding poor performance. So we will be looking at, let me give you a general overview of the areas that we'll be looking at. It's what are ineligibility proceedings, the governing law and rules for ineligibility proceedings, who can initiate ineligibility proceedings, how to make a report, what happens after a report is made, and what are the ineligibility sanctions which can be imposed, requests for reviews and appeals, and record of hearing. So this wouldn't be a long presentation. We'll take you through quickly. So we will touch on what are ineligibility proceedings. Now, the World Bank has published an article called Global Suspension and Debarment Directory. This was a global survey launched in March 2020, and it captured data and information on exclusion systems of 23 different jurisdictions and institutions. And the article provides that many different terms have been used to describe what we call ineligibility proceedings. So you might hear some institutions or jurisdictions referring to it as debarment proceedings, disqualification, suspension, exclusion, or blacklisting. But whatever the label, the general intention of these mechanisms to remove a disobedient supplier from participating in a specific procurement process or from accessing public funds for a period of time. So in our jurisdiction, ineligibility proceedings is a process by which a supplier or contractor or senior officer who has engaged in prohibited conduct is placed on an ineligibility list, which has the effect of excluding them from participating in public procurement proceedings. Actually, this might be an explanation that is a loaded one, so we will break it down further. Firstly, you would notice that certain words are highlighted, that is supplier or contractor, senior officer, prohibited conduct, and ineligibility list. So who is a respondent for the purpose of ineligibility proceedings? You may have noticed that from the previous slide that the ineligibility process is one which is initiated against a supplier or contractor or senior officer who has engaged in prohibited conduct. This means that a supplier, contractor, or senior officer is the respondent for the purpose of ineligibility proceedings. They are the person or entity answering to the allegations raised in the report in this instance. Section 58(1) of the Act goes further to define who exactly is a supplier or contractor or senior officer. In this instance, a supplier or contractor is any person who is a director, manager, senior officer, partner, or other similar officer, or any person who purports to act in such a capacity. And a senior officer is a managing director, a CEO, COO, deputy managing director, president, vice president, secretary, treasurer, CFO, a financial controller, a GM, a deputy GM, a corporate secretary, chief accountant, chief auditor, chief investment officer, or chief compliance officer, or chief risk officer. So what falls under prohibited conduct? The words prohibited conduct are highlighted above, and further to section 58(3, prohibited conduct includes consistently failing to provide satisfactory performance, indulging in corrupt or fraudulent practices, or conviction of an offense under the Act. Additionally, under Section 59(7), prohibited conduct includes offering an inducement or any corrupt, fraudulent, collusive, coercive, or obstructive practice in relation to a tender proposal, and other forms of prohibited conduct pursuant to Section 41 of the Act includes bid rigging or other forms of collusion between all or any of the interested parties to the procurement proceedings, or an irregularity in procurement proceedings or a breach of this Act. So what is the ineligibility list? According to Section 58(1), for the purposes of this section, ineligibility list means a list of suppliers or contractors who shall not participate in procurement proceedings. And Section 58(2) goes on further to provide that the office is the one responsible for preparing and maintaining this ineligibility list in accordance with this section. So who determines whether to impose an ineligibility sanction on a respondent? With respect to who exactly in the OPR determines whether to impose an ineligibility sanction on a respondent, note that there is a hearing panel set up again by the OPR in accordance with the Act to hear and determine ineligibility proceedings. The hearing panel will comprise members of the board and management. You can visit the OPR website to learn more about the current members of the board and management. In order to resolve ineligibility proceedings brought before the hearing panel in keeping with the objectives of the Act, all concerned should be aware of and abide by the governing laws and rules for ineligibility proceedings. And this next slide here touches on the rules and the governing laws regarding ineligibility proceedings. We have the Act, we have the regulations, ineligibility proceedings regulations, we have the hearing rules and procedure for ineligibility proceedings, and the electronic filing and hearing rules. And the Act and regs you can find them on our website. In short order, the rules and the electronic hearing rules will be uploaded. So who can make a report to initiate the ineligibility process? So pursuant to Regulation 3 of the Public Procurement and Disposal of Public Property Ineligibility Proceeding Regulations, if an officer of a procuring entity, a bidder, or a member of the public suspects that a supplier or contractor participating in a contract award procedure or a senior officer of the supplier or contractor has engaged in any of the prohibited activities under Section 41(2) or 3 of the Act, he may bring this to the attention of the accounting officer or equivalent in a public body or to the office in a report together with any documentary evidence at his disposal. Therefore, a reporter again can be an officer of a procuring entity, a bidder, or a member of the public. So how to make a report? How does a reporter make a report to this office? A reporter can submit the report with supporting documents, either to the accounting officer or equivalent of a procuring entity or the OPR via the email ineligibility@opr.org.tt. Regulation 3(2) further states, where as a result of the information provided or subsequent to his own investigation, the accounting officer or equivalent in a public body is satisfied that there is sufficient evidence to support a finding of prohibited conduct, he may transmit the report and evidence to the office. The reporter must provide at least the following details: the name and details of the intended respondent, the grounds or basis on which the reporter is seeking the intended respondent to be placed on the ineligibility list, the facts and evidence to support the grounds of the report, and the alleged prohibited conduct allegedly carried out by the intended respondent. So what happens after a report is made? The diagram you might not be able to clearly see, but when we send the presentation, you'll be able to follow. The pink boxes represent the actions of the accounting officer, the green by the OPR, and the purple, the reporter. So what we wish to draw to your attention is the first two pink boxes. And I'm going to tell you, this shows that the accounting officer equivalent who receives a report must conduct an investigation. And once the accounting officer is satisfied that there is sufficient evidence to support a finding of prohibited conduct, they can submit the report and evidence to the OPR. Alternatively, in the first purple box, you would see that a reporter can submit a report directly to the OPR. So if we turn our attention to the first green box, within 10 days of receiving a report, either from the accounting officer equivalent or from a reporter directly, the OPR will review the contents and decide whether or not to proceed. Your attention is next drawn to the second green box and the connecting boxes. If there is sufficient evidence to support the finding of ineligibility or the imposition of a sanction, the OPR will send a notice of proposed ineligibility to the supplier or contractor which is accused of the prohibited conduct. Note that where the office cannot locate a respondent after taking all reasonable measures, the office may publish a notification of the notice of proposed ineligibility in 2 daily newspapers in circulation on its website with information on how the supplier contractor can contact the office to receive the notice of proposed ineligibility. If the supplier contractor fails to contact the office within the 5 working days after such publication, the hearing panel may proceed with its deliberation on the basis of the evidence before it. If there is insufficient evidence, the OPR would notify the accounting officer or equivalent or reporter of its decision not to proceed. However, the report can be resubmitted to the OPR if new facts or evidence materialized and the report is revised accordingly. The same process applies whether the reporter is an officer of a procuring entity, a bidder, or a member of the public who submitted their report directly to the office. So what exactly is this notice of proposed ineligibility? And this slide provides a snapshot of the said form. It is the document the OPR sends to the respondent informing the respondent of the details of the prohibited conduct that the respondent has allegedly committed and all evidence relative thereto. The form will also include the grounds of the proposed ineligibility, the proposed sanction or sanctions, and the respondent's right within 10 working days of receipt of the notice to provide a written response to the allegations and/or the proposed sanctions. So what should a respondent do when they receive a notice of proposed ineligibility? This slide demonstrates the procedure that takes place when the OPR issues the notice of proposed ineligibility to a respondent. The green boxes represent the actions of the OPR and the purple boxes that of the respondent. We draw your attention to the purple box in the middle and the one to the right where a respondent receives the notice of proposed ineligibility. They are required to submit a response the same within 10 working days of receipt to the OPR and via the ineligibility email. The respondent must utilize the prescribed form, which can be downloaded from the OPR website. The respondent have 2 options of response, that is a notice of intention to contest, which is Form 1. The respondent must provide a written notice to the allegations and proposed sanctions contained in the notice of proposed ineligibility along with any supporting evidence. The second being a Form 2, that is a notice of admission. The respondent must indicate the extent of admission and any representations made in relation to the proposed sanction. If the respondent admits to only part of the allegations, there must be a response to the allegations and sanctions not admitted, along with any supporting evidence. We will now look at the 3 green boxes below. After the respondent submits a response, the OPR will, firstly, within 5 working days of receiving the respondent's response, provide a copy to the person that submitted the initial report to the OPR. Secondly, within 10 working days of receipt of the respondent's response, the hearing panel may dismiss the notice of proposed ineligibility upon concluding that there is a manifest error or other clear basis for supporting a finding of insufficient evidence against the respondent. Where, however, the notice of proposed ineligibility is not dismissed, the OPR will provide notice of the date, time, and place of a hearing to all parties. What happens if the respondent does not provide a response? So, where the respondent does not provide a response to the notice of proposed ineligibility, the OPR can issue a decision and impose an ineligibility sanction, taking into account any known mitigating factors set out in Regulation 6.3 within 10 working days after the respondent's deadline date has passed. The OPR will promptly notify the respondent of the decision in such an instance. The office may also extend the time for the submission of the written reply where a request is made in writing by the respondent and good cause showed. Where a notice of hearing was issued, the hearing may be conducted in person at Level 19 Tower D, International Waterfront Center, 1A Rice Road, Port of Spain, or B, electronically, or any combination of A and B. So can a respondent call witnesses at the hearing? If the respondent wishes to have witnesses present, a written request for permission for the attendance of witnesses in support of his written response must be submitted to the OPR at least 2 working days before the date of the hearing. The respondent must show the relevance and necessity of the attendance of those witnesses. And of course, what happens at the hearing? On the day of the hearing, each party may attend in person or may be represented by a representative, such as an attorney at law, engineer, quantity surveyor, valuator, or agent. If a party fails to attend, the OPR's hearing panel can proceed in that party's absence, noting that the hearing will be closed to the public. Now, these proceedings, ineligibility proceedings, the conduct of the hearing is done in accordance with Section 58(5) of the Act, and that is where a supplier or contractor is accorded with an adequate opportunity to be heard and make representation before he's added to the ineligibility list. So the proceedings will be conducted in this particular form. The respondent or his representative will have the opportunity to question the person who made the initial report to the OPR. Thereafter, the hearing panel will have the opportunity to question the person who made the initial report to the OPR, the respondent, and any other person who was directed to attend the hearing. If the respondent, though, was permitted to produce witnesses on his behalf, the respondent, the person who made the initial report to the OPR, and the panel will have the opportunity to question those witnesses. The respondent will also have the opportunity to make a closing statement in relation to the contents of the notice of proposed ineligibility and can present evidence of mitigating factors relating to the appropriateness of the proposed sanction. Note that where the respondent has filed a notice of admission via Form 2, the hearing panel shall be restricted to the hearing, the allegations which have not been admitted, if any, and any representations on mitigating factors in relation to the proposed sanction. So what can we say about the evidence during the ineligibility proceedings? With respect to evidence, You should be aware of the following. The standard of proof to be applied by the hearing panel is on a balance of probabilities. That is, that the evidence supports the conclusion that the respondent more likely than not engaged in the alleged prohibited conduct. With respect to admissibility, the hearing panel may act without regard to technicalities and legal form and shall not be bound to follow the rules of evidence stipulated in the Evidence Act. Weight, we would be looking at the means the hearing panel may take into account opinion evidence and such facts as it considers relevant, but shall give the respondent the opportunity, if they so desire, of adducing evidence in regard thereto. So when will the decision be issued? Having considered all the evidence, the panel will then issue its decision at the end of the hearing, and written reasons will be provided within 5 working days thereafter. Ms. Maharajh will take you through the following slides, and she will start with what are the ineligibility sanctions which can be imposed.
Thank you, Ms. Mitchell. So as we can see from this slide, upon a finding that the respondent, which would be, as Ms. Mitchell indicated, the supplier, contractor, or senior officer, if any of those persons have been engaged in prohibited conduct, the hearing panel may impose an ineligibility sanction or a combination of sanctions. Note that the imposition of any sanction shall be made public. So what are the sanctions? Firstly, there can be a letter of reprimand, and this is imposed where it is the respondent's first offense and its conduct is relatively minor, or where there are sufficient compelling mitigating factors. We will get into what are mitigating factors shortly. The second sanction that can be imposed is conditional non-debarment. This requires the respondent to comply with certain conditions set out by the OPR within a set time frame, not longer than 6 months. Failure to do so will result in the respondent being automatically placed on the ineligibility list. Conditions can include 1. Actions to improve business governance, including the introduction, improvement, and/or implementation of corporate compliance or ethics programs. 2. Implementation of integrity and/or corporate controls. And 3. Correction of the harm caused by the respondent's conduct. The third and most severe sanction is a declaration of ineligibility. That is, being placed on the ineligibility list for a period of 1 to 10 years. It is the ultimate sanction, and the severity of the conduct will determine the period of ineligibility. Mitigating factors to be considered before the imposition of an ineligibility sanction are outlined in Regulation 6 of the Ineligibility Regulations. Pursuant to same, before arriving at any ineligibility sanction, the hearing panel will take into consideration the seriousness of the respondent's acts or omissions and any remedial measures or mitigating factors which the respondent provides. Factors for consideration include, but are not limited to, the severity of the respondent's conduct, the degree of involvement of the respondent, the magnitude of any losses caused by the respondent, any damage caused to the credibility of the procurement process, past conduct of the respondent involving prohibited conduct, the extent to which respondent cooperated in the investigation, and if that cooperation is of substantial benefit to the procuring entity, whether the respondent has taken appropriate disciplinary action against the individual responsible for the activity which constitutes the cause for ineligibility, and whether the respondent's management has instituted or agreed to institute new or revised review and control procedures and ethics training programs to prevent reoccurrence. As a procuring entity, particular attention should be paid to this slide. Regulation 9 sets out the duties of procuring entities with respect to the treatment of suppliers or contractors and other persons included in the ineligibility list. It provides that the procuring entity shall A. Exclude them from receiving contracts awarded by the procuring entity. B. Not to solicit offers from, award contracts to, or consent to subcontracts with those offending suppliers or contractors. C. The procuring entity must reject any bids received from these contractors or suppliers in response to an invitation for bid. D. Shall not evaluate any proposals, quotations, or offers received from them or entered into discussions with those offending suppliers or contractors. And E. The procuring entity shall not consent to their appointment as a subcontractor to a supplier or contractor who has not been declared ineligible. Please note, however, that a procuring entity may continue contracts or subcontracts that are in existence at the time of the listing on the ineligibility list, unless the accounting office or equivalent in the public body directs otherwise. Notice the highlighted words, may continue contracts or subcontracts in existence. This is important to understand as we move into the next slide dealing with ineligibility exemptions. Here your attention is drawn to Regulation 10, which provides that notwithstanding the inclusion of a supplier contractor on an ineligibility list, a procuring entity may apply to the office for an exemption to conduct business with the supplier contractor on the basis that there are overriding requirements in the public interest which justify the exemption. This applies where a procuring entity may wish to engage with an ineligible supplier or contractor on a new contract. It may be possible to apply to a situation where there is need for a particular good, service, or skill which is specialized and critical that is required to be procured, and the particular ineligible supplier or contractor is the only person or entity with that particular specialized good, works, service, or skill. However, the test that there are overriding of requirements in the public interest which justify the exemption has to be something that can be highly justified to be able to support the argument that an exemption is acceptable in that circumstance. So we turn to a respondent's ability to review a request for the sanction imposed by the office. Respondents can request a review based on the occurrence of one of the following events shown here. One, that there is newly discovered material, evidence, or facts which tend to exculpate the ineligible respondents. Two, a conviction or civil judgment upon which the ineligibility was based has been reversed. Three, there has been a bona fide change in ownership or management of the respondent. Or four, there has been compliance with any remedial, preventative, or other measures imposed by the hearing panel in the context of the sanction of conditional non-debarment. A request where the basis of the request for review relates to the circumstances that were listed in 1 to 3 A, B, or C in the previous slide. A Form 3 request for review must be completed and submitted to ineligibility review at opr.org.tt along with supporting documentation. This form will be uploaded to the OPR's website shortly. Please note that the email address for review is different to the one used to initiate the original ineligibility proceedings. The next two slides demonstrate the procedure where a request for review is made by a respondent. You can see that the first orange box on the timeline starts with Y+. The date was reflected as Y here, firstly to differentiate from the original proceedings, and also to indicate that this date will not be known to us until a request for review is submitted to the office. There is no timeline within which this request for review is required to be submitted. So once submitted, within 10 working days from receipt of this request for review and supporting documentation, an officer duly authorized by the OPR will conduct the necessary checks to verify the information provided in the Form 3 and submit a verification report to the hearing panel. The respondent will be notified of the date of the review hearing and be provided with a copy of said verification report at least 5 working days prior to the date of that review hearing. The said hearing will be held within 10 working days after the hearing panel receives the verification report. And this hearing will be closed to the public. The respondent can be self-represented or represented by a representative. The review hearing will be confined to issues raised in the said request for review and verification report. At the end of the review hearing, a decision will be given and written reasons will follow within 10 working days thereafter. Where the hearing panel decides to withdraw the respondent's name from the ineligibility list, the OPR will inform the respondent, the reporter, and all public bodies in writing within 7 days of its decision. Turning now to where the basis of review relates to the circumstances in D. That is, that there has been compliance with remedial, preventative, or other measures imposed by the hearing panel in the context of the sanction of conditional non-debarment. The following steps are as follows. Prior to the expiration of the time stipulated in the order of conditional non-debarment, the respondent must submit an application for release from conditional non-debarment, Form 4, along with supporting documentation and arguments in favor of its compliance with the said conditions set by the panel. The application shall include, among other things, a detailed report on A, the respondent's adoption or improvement and implementation of any remedial, preventative, or other measures mandated by the hearing panel. B, details relating to remedial actions taken in response to the misconduct for which the respondent was sanctioned, as well as remedial actions against any other misconduct detected during the period of conditional non-debarment. And C, any other matter relating to the conditions set by the hearing panel. The following 2 slides will demonstrate the procedure when an application for release for conditional non-debarment is made. Similar to the previous slides, this timeline, it starts with Z+. So the date is for the same reason for differentiation and the fact that the time frame within which to submit the request for review in this instance is before the expiration of the time stipulated in the order for conditional non-debarment. So within 10 working days after receipt of this request, this application for release, the hearing panel will begin its review to determine, based on the arguments and evidence set out in that said application, and any other factors it deems relevant. The panel will determine whether or not the respondent has complied with the conditions for the order of conditional non-debarment. The hearing panel can direct a duly authorized officer by the OPR to verify the information provided by the respondent, and the respondent must cooperate fully with any such verification exercise. Once completed, a copy of the verification report will be provided to the hearing panel. The hearing secretary shall provide the respondent with a copy of the said report within 5 working days of submission by the duly authorized officer, and the respondent will have an opportunity to provide a written response to any adverse findings contained in that report within 10 working days after receipt. Note that there is no date by which the verification report has to be completed, so as to allow flexibility given that verification depends on the type or extent of conditions being verified and the cooperation by the respondent. The hearing panel can then determine the application on the papers before it. If the panel finds that the conditions set in the order for conditional non-debarment have not been complied with, or if the respondent has failed to submit an application for release within the time frame specified, the respondents will be placed on the ineligibility list. Note, however, the hearing panel may accept an application with sufficient reason within a reasonable period after the time frame specified if the respondent provides sufficient reasons for the late submission. The respondents will be informed of the decision and provide with written reasons for same within 20 days. If the hearing panel finds that the conditions set in the order for conditional non-debarment have been complied with, the respondent will be issued with an order of release, thereby being released from further obligation under the terms of the order of conditional non-debarment. So with respect to appeals, please note that pursuant to Regulation 7.2, the decision of the office shall be final and shall take effect immediately without prejudice to any other action taken by any government or organization under applicable law. And lastly, with respect to the recording of the hearing, the office may be provided the recording the office may provide the recording of the hearing in one of the following formats based on availability, either an audio file or an audio with video recording. All parties shall have access to copies of the record of the hearing within 14 working days of the decision of the panel by filing a request for access to the record of hearing, or Form 5, with the hearing secretary. This brings us to the end of the presentation with respect to ineligibility proceeding.